Listen-only mode.
Good morning, everyone. Representing persons with mental illness, sponsored by the Family Defense Center and the Illinois Parent Attorney Network. I'm Diane Redleaf. I'm the Executive Director of the Family Defense Center, and we are the coordinators of the network. Thank you for coming. We have a very exciting program today. I'm going to get started in a minute with introducing our first speaker. But first, I'm going to introduce Kent Dean, who is coordinator of the CLE and other aspects of this program. So, Kent.
Good morning, everybody. For those of you that are online, I just want to remind people you should have received a evaluation form. You fill that out, and you should have tendered it and do the request for your CLE. Thanks. I'll remind you again.
So just a basic introduction to this topic. We originally, when we were planning training, we wanted to have training on the whole area of mental health. And we discovered that that topic was huge. Not a surprise to our presenters and probably to our audience. But what we did was we started out with a full day training at our last training on the issue of assessment, psychological and psychiatric assessment. So we did not deal with the ethics issues, we didn't deal with representation issues, we didn't deal with competency issues, we only addressed the issues that we see in our practice involving assessment. So we decided to do a second part training, and that is today, on the many related topics of representing persons who have mental illness. We're very fortunate to have some of the national experts on this on this topic who are presenting with us today. And first and foremost of those people is Marc Heyrman, who I don't know how far back you go, Marc. I know I've known you for some probably 25 to 30 years. He has been a clinical professor at the University of Chicago in the field of mental health law for as long as I've known him, and he's been at various times the head of the clinic at the University of Chicago, and he's been in charge of the effort to rewrite the mental health code and other very notable projects involving policy and practice in the mental health field. So I really do consider him the guru of mental health law, and we're very fortunate to have him. Thank you.
Thanks so much, Diane. So I'm pleased to come and speak with you about this for a number of reasons, and largely because it helps me to reorganize and rethink about what I do and have been doing. For longer than Diane stated, since 38 years I've been representing people with mental illnesses, and I would say 98% of my clients in the last 38 years have been people with mental illnesses, self-identified or perhaps identified by virtue of being confined to a psychiatric hospital or otherwise. So this is a difficult topic, and in the sense that there are all kinds of different things one does with people with mental illnesses in the legal system, all kinds of different contexts in which one represents them. And of course, as you probably know, there are all kinds of different mental illnesses. So we'll talk just a little bit about thinking about some of our mental illnesses. I'm not a psychiatrist, so I'm not going to give you a course of mental illness. But either for good or for ill, I've learned a lot about mental illness and its treatment over my 38 years. And I think, so I'm going to tell you suggest to you some diagnostic categories, but I'm going to suggest to you that these, for most of the reasons that you will be thinking about how this affects your legal work, the diagnostic categories are less important than the functional effects that these diagnostic categories may have on your clients. So we can start with the most serious mental illnesses. So typically the thing that people think about when they think of mental illness, and this scary images are people with the most serious illnesses, and those, of course, are the psychotic disorders, typically in the family of schizophrenia. There's different diagnostic categories within schizophrenia. And I'm just going to talk about these in the sense of the kinds of things that you may see, that even a layperson will see, that may affect how you relate to the client. So the client may have delusions. Briefly, what are delusions? They're fixed false beliefs. So I believe, I actually do have a client who believes that he is the king of Egypt. And other than that, that was a protest from Egypt. He's a very intelligent guy. You can have a conversation with him about almost any other topic, in which he will give you completely coherent answers. He, in fact, while confined in the psychiatric hospital, having been found not guilty by reason of insanity, is enrolled in college courses by a distance learning program, has earned a lot of college credit. And as far as I can see, his mental illness is in no way interfering with his intellectual functioning. But if you want to talk to him about why it's illegal for him to be confined in a state psychiatric hospital, there's a very clear answer. The United States government does not have jurisdiction over him since he's the king of Egypt. All of you know enough about international law to know that clearly is true. If he were the king of Egypt, it would probably be wrong for us to be arresting him and putting him in a mental hospital. But in fact, he's not the king of Egypt. So if you need to talk to him about some of the matters relating to how he got there, you will get mostly answers relating to this delusional belief. The problem with delusional beliefs is that it's often very difficult to deal with them. And let me suggest a couple of things that are at least simple and reasonably effective ways of dealing with people with delusional beliefs. And they're sort of at both ends of the spectrum. It is usually not helpful to quarrel with someone's delusional beliefs. Okay, you are not going to talk someone out of their delusional beliefs. You are not. And I have never spent a moment's time trying to convince my client that he is not, in fact, the king of Egypt. Thankfully, it has nothing to do with my representation of him. We'll get to that because that's important. The other thing I would say to you is that there's no reason you need to agree to your client's delusional beliefs. And you need to at least get some sense of what the parameters of the delusional beliefs are, and make sure that you don't end up supporting your client's delusional beliefs. I actually have seen a case taken to the United States Court of Appeals for the Seventh Circuit, in which lawyers from a very large and prominent Chicago firm, which I won't name for obvious reasons, litigated the client's delusional beliefs. This was their legal theory in the Seventh Circuit. Okay, they lost. The client's delusional beliefs were not supported by any facts. So there's no reason for you to agree with the delusional beliefs. Now, the part of the problem for lawyers may be to figure out, sometimes delusional beliefs are hard to separate from reality. It's fairly easy for me to understand that it's extremely unlikely that my client who believes he's the king of Egypt is in fact the king of Egypt. That was easy for me to figure out that wasn't true. But sometimes it's not so clear. Some of the most difficult delusional beliefs are, of course, paranoid delusional beliefs, in which you believe that people are out to get you. And those are the kinds of delusional beliefs that more frequently than not may end up with someone being in a psychiatric hospital, particularly depending on the content of those delusional beliefs. But among the reasons it's useless for you to quarrel with someone's delusional beliefs is immediately that your client will figure out a way in which you are part of the problem. They will simply come to believe, the reason that you're disagreeing with their theory that they're the king of Egypt is that you're part of the conspiracy to keep this person off the throne of Egypt, which is legitimately his. I did have a client who had the delusional belief that I was God. I quickly saw through that one. My last name is Heyrman, and he said, at the time I had a big beard and long hair, and I looked a little bit like Jesus. Looked a little bit. Other than that, I have no nothing in common. And he thought that my last name, Heyrman, meant that I was higher than man, that he was the only person who understood that my last name was a code, and that I was here in disguise. So if you wish to believe that I'm God, I don't mind, but you won't convince me. I have not gotten that crazy during my 38 years doing this. So another common thing that you will see with people with very serious mental illnesses is hallucinations. That's fairly straightforward. We're talking about people who see, hear, or feel, or taste things that aren't there. The most common thing is that people will hear voices telling them various things. And unfortunately, for lots of people who have those are just called auditory hallucinations because you're hearing them, the voices often say very negative things. These voices, people with serious mental illnesses, schizophrenia, can be taught to ignore the voices. You can learn to ignore people in the real world who criticize you and say you're a bad person. And often, a lot of times, the voices that people will hear will be condemnatory of them. They will be telling them you're a horrible person, and that's not good for your ability to function. But we have treatments, cognitive treatments that help people to not turn off those voices in the sense of not listening to them. That person, the person that's talking to me and saying these bad things to me is just wrong, and I don't need to listen to him. Medications work quite well with hallucinations, but they can be quite disruptive. If you're talking to someone and the person is highly distracted, it might very well be that rather than listening to you and talking to you, the person has a much louder voice. I have a loud voice, but this person has a much louder voice in her head or his head than the voice that you're trying to speak with him to. Again, the nice thing about hallucinations is they're much more easily treated with medication than delusions are. Mood disorders, you're much more, so the prevalence of schizophrenia is about 1% in the population. So, and not so much true of children, so we have 13 million people in Illinois, about 100,000 people have schizophrenia. Mood disorders. So mood disorders are much more prevalent. And there are several different kinds of mood disorders. So you've probably heard of bipolar disorder. Bipolar disorder comes in different types, but most commonly we talk about it as being the new word or the new phrase for manic depression. People are too high at some point and too low at other points. And the problems with being too high frequently is sometimes when people get too high, they become psychotic. That is, they begin to lose touch with reality. They have a misunderstanding, misperceptions of the world. At the extreme end, people with bipolar disorder will take all of their life savings and run to Las Vegas and put it on red. If they win, that's a great strategy, but that's a pretty risky maneuver to take your life savings and do that. That's actually not such an uncommon thing that happens with people who have bipolar disorder and are in the manic phase. Unfortunately, or fortunately, there are mood swings, and people who get very, very high often then crash and get very, very low. And psychosis can accompany very serious depression as well. And the prevalence of bipolar disorder, we're less in agreement about. It's between 1 and 2%. So probably at least 150,000 people in Illinois have bipolar disorder. Bipolar disorder tends to be less disruptive, so there are plenty of people in public life, I won't name names, who have bipolar disorder. If you're a little high most of the time and have an excessive view of, optimistic view of the world, that can be very useful if you're a politician or an entrepreneur. A substantial percentage of entrepreneurs, more than the 1 to 2% of the population, are people with bipolar disorder that is in reasonable control. If your bipolar disorder is reasonably controlled and you don't go off either end, you can function reasonably well. And again, we have good medications for bipolar disorder. Historically, we used lithium, and there are a variety of other medications that work for bipolar disorder. And so it's a highly treatable illness, as is schizophrenia, highly treatable illnesses. They're not curable, but they're highly treatable with medication and with other therapies. So
Part of the problem with bipolar disorders is they do affect judgment. So if you're in litigation with someone who is excessively depressed, they're going to be extremely pessimistic about the outcome of anything that you do for them. And that may affect your ability to deal with them about suggesting alternatives. Should we do this or should we do that? Doesn't matter, nothing's going to work. On the other end, it may be impossible to convince someone who is too high, too manic, that filing a lawsuit isn't just certainly going to win immediately. You'll get the sun, the moon, and the stars, more than you even asked for in your litigation. The court will see how wonderful I am, will see that I'm deserving of everything that I ever have asked for, and it may be difficult to talk that person out of their excessive optimism. It's a mood, and mood, of course, affects judgment. Unfortunately, another too common result of depression that associated with bipolar or depression otherwise is suicide. And so people who are very, very depressed are the most commonly associated with suicide. We have a fairly substantial amount of suicide in this country. Substantially more people committed suicide last year in the United States than were the victims of homicide as often as we have homicide. So between 35 and, it's hard to, we don't have good data, as good data as we need, between 35 and 38,000 people committed suicide in the United States last year. More like 30,000 were the victims of homicides. Of course, lots of people don't have manic depression, but they may have chronic depression, which may come and go and may be quite severe. A fairly high percentage of the population suffers from depression at some point. That's a fairly normal thing. If depression usually, if it's sometimes without treatment, but with either talk therapy or with medications, or better with both talk therapy and medications work quite well for depression, and then often goes away without any treatment at all. But if it lasts for quite a while, it can be quite debilitating, keeping people from going to work, people who are profoundly depressed. Part of the problem is that even though their intellectual functioning may remain unimpaired, and you can talk to them about, well, you know that you've been depressed many times before, and every time you got better, this time is different. That's their view. A common phrase that we use for people with very serious depression is that they feel helpless and hopeless. There is no hope for me to recover from this depression. And the fact that I recovered every previous time means nothing. And no one can help me. And there, as one of my friends who suffers from chronic depression says, he knows that if he would just walk into the bathroom and take his medication, he would feel better shortly. He doesn't have the energy to get out of bed. He doesn't have the energy to pick up the phone and call a friend. He doesn't have the energy to pick up the phone and call his doctor. He is too depressed to do those things. And he's thinking in his head that he knows that these things would be good, but he can't do it. He can't do it. And that's a pretty debilitating thing. Again, depression is highly treatable with medications and with talk therapy. Personality disorders. Personality disorders are very, very difficult. And we'll just say a few words about personality disorders and how they may affect your representation. So borderline personality disorders are often accompanied by an extreme need to be connected to folks and to want attention. And so one of the things that is often said in the psychiatric community is, if at all costs you avoid putting someone with a borderline personality disorder in a hospital, okay? Because even though most people hate being in the hospital, and they do too, it's very difficult for them to leave because they're getting so much attention in the hospital. You get more attention in a hospital than you get at home usually. People are watching you 24 hours a day, 7 days a week. And indeed, in hospitals, a long time ago before I became a lawyer, I worked in a very nice private psychiatric hospital. And we had 5 levels of care. And if you moved someone up to a higher level of care, it was very difficult to get them to a lower level because they would do something just before they were ready to be moved to a lower level of care to keep where they were because they needed the attention. So it's a very difficult. So how does that affect, for example, divorce? You will find that people who have borderline personality disorders will, even if they're the interaction they have with their spouse, their ex-spouse, their soon-to-be ex-spouse is entirely negative. They would rather have negative interaction than no interaction at all. Very difficult for them to let go of anyone, including their lawyer. And so that's a problem for folks. Narcissistic personality disorders, well, I want to be absolutely clear. One of our presidential candidates does not qualify because this disorder has to be result in negative consequences for you. So if you've ended up, because of your narcissistic personality disorder, having 25 to 30% in the polls and $10 billion, you do not have narcissistic personality disorder. Every other criteria of that disorder, one of our candidates has, but he cannot be diagnosed as having personality disorder because it's functional for him. The fact that, for example, you say to him, you said this yesterday and you're saying this today, you say, yes, but I got 40% in the polls. So inability to accept anything negative. You'll never say, I made a mistake. You'll never say you're sorry. It's always, I'm the most wonderful person. Did you read my book? I haven't written. And et cetera, et cetera. I cannot allow a conversation with another person to talk about anything that might be wrong with me, that I might have made mistakes in the past, that I have ever been anything less than perfect. Very difficult to accept. That often affects judgment in terms of trying to figure out, and have a reasonable conversation about the merits of one's case, particularly if it involves my behavior last year, 2 years ago, how good a parent I was, how good a spouse I was, et cetera, et cetera. Very difficult to have a conversation with someone who finds it very difficult to acknowledge anything that ever went wrong in the past. There are many other mental illnesses. I'm not going to talk about them, except I'm happy to respond to questions about other ones if I can be helpful. So the thing that the most important thing you must figure out when you have someone with a mental illness is to what extent does the mental illness relate to your representation of her or him. So you can think of a variety of ways in which it might interfere with your relationships. One, your client may be unable to trust you. If your client has tendencies toward paranoia, may believe that you're not untrustworthy. It may affect your ability to trust the client. The client may tell you different stories at different times, not because the client is lying, but because the client believes different stories at different times. It also makes it difficult to formulate a rational goal for the representation. So are you able to do that? You need to make some assessment. So when you say, look, now that I've done all the research that I can, factual research, legal research, and to figure out what I can achieve with you to achieve your goals in this litigation or other kind of representation, can you have a conversation with the client in which the client can make a reasonable assessment of that? Does the client know what the risks are if you go to trial? Does the client know what the upside rewards are? Does the client really appreciate that? And that's the heart of the matter for me, is sort of, does the client know what those advantages and risks are? And of course, that then, the client's ability to make a decision is really all about the ability to choose among various choices. And so with mental illness, this isn't an intellectual problem. People can be smart or not smart, and people with mental illnesses have the same range of IQs that the rest of us do. It's about the ability to evaluate those options. Yes, I understand that, but no, I can't really appreciate that is a likely outcome or an unlikely outcome. And then can the client stick to a decision? So sometimes it's useful for you to sort of give yourself, if the litigation schedule permits this, I understand it often doesn't, some time to sort of make sure that the agreement you have with the client today is going to be the agreement you have with the client tomorrow, or even better next week. So it's often useful to take a little more time, if you have it, to sort of say, well, you know, we talked about this yesterday. Do you really agree? You agree that this was our best strategy to achieve your goal? Is that still your opinion? Is that still your opinion? Because you may find people who are changing their mind, and you need to figure out to what extent. Yes.
How do you approach the problem with telling the client what he's diagnosed with, or how do you get around that? I mean, certainly you have the medical history of the client, you know what he's diagnosed with, and certainly he may not agree that he's diagnosed with that. Do you even discuss that?
Well, again, it depends upon what, do I need to discuss this for the case? And part of the, so that really brings us to the second bullet point there, the relationship to the subject matter. So sometimes you don't need to do that. And so it really turns a lot on to what extent is the mental illness going to be intricately involved in the representation. So if we're talking about the ability of someone to parent, and I have to tell you that I don't do family law cases. When I first started out in this business, I did for a period of time represent mentally ill moms who were in disputes with DCFS. But overwhelmingly, I have not done that in my career. But if that's the issue, then obviously the ability of the mom to parent is going to be central to your litigation. And if that's central to your litigation, then you're going to have be able to talk with your client about her or his ability to parent, because that's what's going to be litigated if you end up in a fight with the Department of Children and Family Services, or if you end up in a fight with the other parent. And so the good news is that this isn't, you're not going to give the patient the client a diagnosis. You never should do that. I assume that maybe there are some mental health professionals in the room. I'm not one. I never pretend to be one. And I never suggest to a client that she or he has a diagnosis unless it's been diagnosed by someone else. But once it has, it seems to me, you probably do need to have a conversation. Look, you were examined by this psychiatrist. This psychiatrist says this is your diagnosis and says this is the effect on your abilities. And you have to have a conversation with the client about that. And if the client disagrees, you can say, then the question is, in the course of the litigation, can you afford to get another opinion? Is there reason to do that? Is there reason to think that the psychiatrists, like all other experts, including lawyers, make mistakes? They have errors in judgment. They have errors in diagnosis, and it's often useful to get another psychiatrist's opinion on this, or psychologist. But I probably are going to have to deal with the medical records with the client, the psychiatric records, and explain that the lawyer on the other side is going to introduce this if this goes to trial. That they'll have their expert, and their expert will testify that you are unable to do X, Y, and Z due to this mental illness. So I see no way around that. And if it's central to the litigation. Sometimes it's not. As I suggested in my opening remarks, the work that I'm doing for the King of Egypt has nothing to do with the fact that he's the King of Egypt. He wants to sue the department over his access to, continued access to online courses. And in my view, he has a statutory and constitutional right to that. And he never speaks with me about his reign as the King of Egypt, future or past. It's really irrelevant. He does wonderfully in school and has a right to, in my view, the judge will decide, to continue to access that right while in the psychiatric hospital. Yes?
What do you do, and this is, I think, a fairly common problem for people who are appointed to represent parents. You get a parent who is mentally ill, and as part of their mental illness, they don't think they have a problem.
Yes, so the question is, what do you do with someone who has a mental illness and as part of their mental illness is unable to acknowledge their mental illness? So that is a problem with more serious mental illnesses. Certainly it is a problem with psychotic illnesses. My client, who's the king of Egypt, doesn't think that this is a delusion. He thinks that these people are, he doesn't believe he has a mental illness. And so that's, the question is, how are you going to deal with that? And it seems to me you start with, well, you could be examined by a psychiatrist. How do you know this person has a mental illness?
Because their history and also the fact when you bring up something about this and they say, well, such as taking medication, and they say, no, I don't need to do this. You know, I want my kid that. There's no reason, you know, there's no reason.
So it seems to me you deal with this the way you deal with any litigation problem, which is to say, look, this is going to be the issue in the hearing, and when this case gets resolved, either by negotiation or by a judge or someone else who gets to decide these things, and the lawyer on the other side is going to bring in a psychiatrist who says you have schizophrenia and you need medication, you're not taking it. So if we're going to combat that, I can have you seen by another psychiatrist. We'll pick someone, but if that psychiatrist says to you, this person that you have this mental illness, then what your job is to explain to the client that I understand you don't believe that, but how are we going to prove that? How are we going to prove that? Because we've got an expert on the other side who says you're mentally ill. How are we going to prove that? And if the client says, well, what's the conversation? It seems to me at that point you have a very direct conversation with the client that says, there is no way, given the evidence that we have, that we are going to be able to establish that you do not have a mental illness. So, what do you want to do? What do you want to do? Because these are your choices. And you don't have to admit you're mentally ill, but you may have to agree to get treatment. And I'm perfectly happy with my clients if they say, I'm not mentally ill, I'm just doing this because these crazy people who have a bad judgment about me say I need to take medication. I very much want to have this result, in your case, my kid, my children. And so I will agree to the treatment despite the fact that it's based on a complete misunderstanding of who I am. I'm not mentally ill. You often don't have to compel your client to agree to be mentally ill. Who wants to stand up and say they're mentally ill? There's a lot of stigma attached to mental illness. It's difficult for people to admit they're mentally ill. Is that a little bit helpful?
Yes.
Okay. Sometimes at the end of the day, this is just impossible, which is to say you can't possibly get what the client wants because the client won't agree to the one path that gets you to what the client wants. That's where the rubber meets the road with representing people with mental illnesses, or lots of other people who don't have a diagnosed mental illness. Yes, I'm innocent of this crime, but there are 37 witnesses. Well, sorry, I want you to go to trial and get me an acquittal. Well, no, that's not going to be good for you. You should take this plea bargain. Well, often that's not the result of mental illness. That's just, I don't want to admit I did anything. And you are stuck, if you're in that situation and you're appointed public defender, with doing what the client wants, even though you have tried to talk him or her out of it, and the goal that the client wants is unachievable in the way that the client wants to achieve it, which is to say the client is not going to be acquitted when she or he goes to trial, because there are 37 witnesses. They all say he did it. And there's no way around that. You can't change the world. And you've tried to affect your client's judgment by giving your best judgment. But I don't think it's helpful to pretend that the evidence against the client will go away, and that's, again, participating in the client's false belief. And you can offer various alternatives to the client about, well, who would you believe? If you're not mentally ill, how about being seen by this person? The client might be right, but I suspect not. No magic bullet, sorry. That's the problem that is in some sense insolvable if you're the appointed lawyer and there's no one else who can do this, and you can't achieve the client's aim. So obviously, in many cases, the client may also have to testify, and you're going to have to figure out whether the client can do that. That may be that the client can testify if she or he is getting appropriate treatment, maybe just wonderful. Again, most mental illnesses are highly treatable. Some are curable, but they're all treatable. The most serious ones, unfortunately, not curable, but highly treatable. And there's no reason to think that someone can't be successfully treated and then may be able to testify. But obviously, that's an assessment that you're going to have to make. It will be very helpful for you to have an expert who can give you an opinion on that. It is often useful to talk, if you have an expert, and you will often need to have an expert, to actually ask the expert whether the stress of testifying is something that this client can endure in his or her current condition. Because the answer might be no. The client might be doing okay, but being forced to testify under oath in a contested hearing with a lawyer on the other side who's doing her or his best to cross-examine your client and to undermine her or his testimony and is maybe very mean to your client. That's part of the process of litigation, for good and for ill, and will the client be able to stand up to that? That's sometimes an assessment that you can make, but often one that's best made with the assistance of some kind of mental health professional, psychiatrist or psychologist, social worker sometimes. And that if the client can't testify, you need to have a conversation with the client about whether or not that means what that means for the case. It might be the end of the case. In many cases, if your client can't testify, basically you lose. You lose. In other cases, it may be unimportant. In my client who thinks he's the king of Egypt, I'm fairly confident will never have to testify in our class action about access to the internet for college credit. I've made that assessment. We have many other people who can testify. I think he probably could, but his credibility might be undermined if they start asking him why he's in the hospital, and that might not be good for him because he won't admit it, and I think the trier of fact will certainly believe that he's not the king of Egypt. But we're lucky to be in a litigation posture in which he won't have to testify. So that's an important consideration, is interfering with the client's credibility beyond simply thinking about the ability to get up and withstand direct and cross-examination. So let's talk about the most important question. So the first thing you figure out with any client is what the heck does the client want? And often that's something that's difficult to ascertain. If you're been appointed and you're in a particular litigation process, you at least have a helpful hint about what that is. But it nevertheless is something that needs to be done very carefully. Clients may feel that they must be asking for something because otherwise they're not a good person. So I have to say I'm not mentally ill because it would be hard for me to admit that I'm mentally ill. I have to say that I want to have my children back when maybe I feel overwhelmed and don't want them back. I have to say that because if I don't want that, I'm not a good parent. Every good parent would always want to keep their children, and if I don't want to do that, I must be a bad parent. You need to get to the bottom of whether or not that's really what the client wants. A mental health professional can be helpful with that. That is to have the client talk with someone about whether this is really true. Is this true? And clients often articulate what they want in ways that are at a 90-degree angle from what the legal system is about. That is, one shouldn't expect, and of course lawyers understand this even from people who aren't mentally ill and even from people who are quite sophisticated, that what they say they want may take some digging to get to the bottom of, and may not be something that the legal assistants are for. The legal system gives to someone, but that doesn't mean that after some digging you can't figure out that there is in fact something that a client wants and that that is in fact an achievable goal. But among the most difficult conversations with clients is this an achievable goal? Can you get what the client wants? Yes.
Sorry, how do you, I don't think how to phrase this properly. If you feel like your client wants one thing, but you know that they have this mental illness where their judgment is easily influenced by other people, like family members or something. Yes. So how do you kind of your client's wavering and you feel like what they want is one thing, but due to the influence of other people, they might be telling you something different at different times. Do you go with your instinct, or I don't know, I just don't know how you juggle that.
Well, that's an extremely difficult thing, and my own view is if you have this available to you, that's where a mental health professional can be really helpful. In that context, I would say as much a social worker who would go in and look at that family and sort of talk with the entire family and find out what in fact is going on. That is, you need to understand the interpersonal dynamic going on between your client and those other people who may be influencing them. That's a conversation that perhaps you can have with the client. I wouldn't start from the assumption that you can't have that conversation, in which you simply say, well, I wonder to what extent, this is what you really want, or whether other people are pressuring you to do this. Because in the end of the day, this is your case. I'm your lawyer. I don't represent them. And we need to figure out what you really want and what you can do. And is this what you really want? And again, I think this is a particular context in which my earlier suggestion is that to the extent the litigation process permits this, you try to take some time. So today the client says this, and then tomorrow says something different, or a week from now says something different. And also, it seems to me, you may see that the client says one thing but behaves in another way. And there is nothing wrong from pointing out the ways in which clients behave, which may be hurting their claims. So you say you want this, but you didn't show up for these appointments, you didn't do this. Do you understand that that may be hurting your case? And, I wonder, and that's an occasion for you to say, I wonder whether that, that's part of your uncertainty about whether you want that. And we can take some time and think about this, because it's not crazy to be ambivalent about these important life decisions. If you have a serious mental illness and you recognize how it has affected you, you might indeed be highly ambivalent about wanting to and having the ability to take on various responsibilities or continue to have responsibilities over children, etc., or all other things in life. And, this is a difficult decision for people with serious mental illnesses about whether to go to work or not, or to get disability benefits. People don't want to admit they're disabled, and people want to have the money and the self-esteem that comes with working. And the question is that a realistic prospect for me? And that might be a very difficult decision for me. And so I would start by having whatever conversation you can have. If the client doesn't want to have that conversation with you, I think it's maybe important for you to see if you can get someone else to have that conversation. Because again, we can be smart lawyers, but we're not mental health professionals, and there's a limit to what we can do in that regard. And it's important for us to be good listeners, but not to overstep our skill set. Lawyers do a lot of counseling, and so in many sense, there's a great New Yorker cartoon in which this lawyer says to a client in his office, he says, well, I really appreciate you telling me your deep and innermost thoughts, but you need to remember I'm just your lawyer. And you are just their lawyer. And at the end of the day, there are people who get paid to do this, to help people with serious mental illnesses deal with their serious mental illnesses, and it's not us. We're not trained or qualified to do that. So you must use your judgment, yes, and then figure out when oops, I don't know what I'm doing. The client did not respond to that in the way I expected her or him to respond. And I'm not getting to a meeting of the minds between me and the client. In fact, it seems to be getting worse. She seems to be more confused about what she wants, or I'm more confused about what she wants, which might also be true. So it's a very difficult problem. So one of the things that's nice about being a lawyer, I have found, is that, and particularly, is that clients want what you have. That's why you're helping them. They want your legal assistance. And you know how the legal system works, and you know how to get what is achievable in the legal system. You have skills, you have experience, you have training, you have education, and that's why the client has come to you. And that does give you some leverage with clients. It doesn't give you overwhelming leverage, but it does give you some leverage, which is to say, you always have the ability to say to clients, look, I think we can achieve your goal together. I'm willing to work as hard as I can to achieve that goal, but that's not going to work unless you get some treatment. We're not going to be able to do this unless you get some treatment. Here we have this report from a psychiatrist that says you have some untreated mental illness, and the only way we're going to get what you want is if we get that illness treated so you can be fully functioning. And when that's happening, then I think we can work together to get what you want. But if you don't agree to that, I don't see how I can get what you want, which I want because I'm your lawyer, I'm your agent. And that's a piece of leverage that has to be used carefully. So you shouldn't be coercing people into doing things that you don't have a basis for coercing them into doing. This is a form of coercion because they want you as their lawyer. Presumably they can go somewhere else. Sometimes they cannot. If you're the appointed lawyer, you're it. And that puts you in an extremely important position, which is a difficult ethical position. But if you understand the situation the client is in, that's why you're a lawyer. You have an ability to assess what the prospects are. Within, obviously, always difficult to make predictions about how courts will decide things, but that's why we do what we do, is to be able to make those predictions and make our best judgments. So that's a piece of leverage that we can use with clients if we do so carefully and when we know we're on the right page. So what can you do when you have a client that you've come to a loggerheads with? Client can't agree with you. You want to be able to help the client. You think it's possible to help this client, but you've got a bunch of problems. So one, maybe you can get treatment for the client. Maybe the answer to that is no. And maybe the treatment will not get the client to the position that where she or he can do the things that are necessary for the litigation. So then the question is, what else can you do? Well, you can get others involved. You can get a guardian ad litem appointed. The rules permit that. The ethical rules are mostly commonsensical in this regard. I've reproduced them for you in the materials. And the basic goal when you have someone with any kind of a disability, the admonition of the ethical rules, which I agree with completely. I don't agree with every detail of ethical rules, but I definitely agree with this one, is you should try to maintain as normal a relationship with the client as you can, Of course, the problem is, what if you can't? And so it may be necessary to have a guardian ad litem appointed who can make decisions for the client. That is, if the client can't make decisions, can someone else be appointed who is, because the problem is that lawyers are simply agents, and an agent has to have a competent principal to give her or him direction. Basic law of agency, we learned in law school 102 years ago in my case. I still remember it. You have to have a competent principal or you have a hard time making these decisions. Of course, in the end of the day, you can withdraw from representation if you think you cannot, the client absolutely is adamant that he or she wants A and B, and you can't do that. You can't do that. then you, at some point, you can withdraw from representation. At some point, you probably must withdraw from representation. The client wants you to do something that is unethical or to make an argument that is not well-founded in the law. That's a violation of the ethical rules. To make an argument that is for which there's no basis in fact, you can't do that. And so then the more difficult question is, how do you communicate with courts? And again, the ethical admonition is fairly straightforward, and I suspect that most people will get this. That your job, no matter, whenever you must communicate with the court, is to do so in a way that least harms the litigation interests of the client. So the part of the problem is that this gets most difficult when an issue in the litigation may very well be the client's capacity to be a parent or the capacity to do anything else. And you're talking, and if to the extent to which you are communicating to the decision maker that the client has some mental health issues, you are undermining the client's case. So as a general matter, my advice to lawyers is that they should communicate as little as possible. And a simple way that you can withdraw representation is to say you can't reach an agreement with the client about the goals of the representation. You cannot represent a client that you don't have an agreement about. That happens all the time with people who aren't mentally ill. It does not in itself communicate mental illness to the decision maker. And if you can do that and get yourself out of this predicament, that's how I urge you to proceed. So here are the ethical rules. This is the basic rule. Client with diminished capacity is Rule 114. You see the first bullet point, the lawyer shall, as far as reasonably possible, maintain a normal lawyer-client relationship with the client. Then if there are other paragraphs all allow you to take other steps like asking for a guardian ad litem, withdrawing from the representation. And again, the admonition is to communicate as little as possible that will interfere with the client's interest in this litigation. And that's true for some fairly obvious reasons. You may say, well, this client is going to lose no matter what, so how could that hurt them? But the bottom line, one of the things we know most about mental illnesses is that they are relapsing and remitting conditions. And by that I mean the most serious mental illnesses like schizophrenia, bipolar disorder, depression, the serious symptoms of them come and go. Today, my client may be really, really doing well, and tomorrow she may be doing not so well, or next week, or some months from now. And it may very well be that today, because it is simply impossible, I must withdraw from representation. But another lawyer is appointed, the case gets continued. 2 months from now, the case goes forward, the client is doing much better. And it's not your fault. It's not that the client couldn't get along with you, I hope. Or the other lawyer is a miracle worker. It's that the client's condition has improved. That's a good thing, a not uncommon thing, that people get better, they also get worse. And so at that point, someone else may be able to go forward with this case. And so you will not have hurt the client's interest by saying anything negative about the client in your effort to get out from under a representation which is no longer tenable. You cannot agree with the client about what he or she wants. Yes?
Well, I did not bring my copy of the rule of professional conduct with me, but I have a case somewhat like this, and I seem to think there's some conflict between this and being a court-appointed attorney, like in withdrawing, that it's not quite so simple. Do you know have any comment on that? If you're an assistant public defender or some other court-appointed role, and your client is of diminished capacity, getting out of the case.
Yeah, this is easier for criminal defense lawyers usually, because we have. I'm sorry.
Can you please read the question?
The question is whether there is a conflict between the ethical rules about representing people with diminished capacity and perhaps withdrawing, which is one of the clearly available options, and what happens to you when you're a court-appointed lawyer, like a public defender. So I'll talk about the easy one first, the public defender. Some of my best friends are public defenders. And the easy thing about being a public defender, easier, is that we have, by constitutional provision and by statute, rules about fitness to stand trial. And those rules, in some sense, conflict with what I've suggested, but not too much. So fitness to stand trial in the criminal context means that the defendant is capable of understanding what the criminal trial is about, and also is capable of participating with the lawyer in litigating the case. So if your client thinks that you are part of the conspiracy to have him subjected to the death penalty, even though Illinois doesn't have it, and you probably can say to the court, I think my client may be unfit to stand trial. And there is some conflict about to what extent you even have an obligation to do that, even if you think it's not good for your client to be to go forward with fitness determination. There's a fair amount of case law that says that you have an ethical obligation to the court to disclose the client's potential unfitness, which could undermine the legitimacy of the criminal trial. But in any event, it's absolutely clear that the ethical rules do not prohibit you from telling the court that your client may be unfit to stand trial. Your client will then get an independent evaluation from a mental health professional, and then an independent decision from the judge. Presumably that says whether the client is unfit. The client will be sent off for treatment. His criminal trial, which is the subject of your representation, will be suspended pending restoration of fitness. Overwhelmingly, criminal defendants who are found unfit are restored to fitness, come back, and stand trial. And then the question is, did this communication to the judge undermine your defense? And the good news is that usually the answer to that is not, for a variety of reasons. Again, most cases end up with plea bargains, so if you are now in a position to communicate with your client and she or he can make a decision about a plea bargain, that's cool. And then lots of criminal defendants don't testify, but in any event, if it's a jury trial, the fact of the client's previous unfitness will not ever be divulged to them. That would be wrong. Yes, keep going.
No, what, in my context, I should have been more clear perhaps.
Yes.
Assistant public defenders are also appointed in civil proceedings with in juvenile abuse and neglect proceedings. These are civil in nature, and the whole issue is the Department of Children and Family Services and the state's attorney's office is trying to say that your client with a mental illness is not fit to parent their child. So, you know, if you say, well, my client's unfit, you've already lost the case for your client. So what I'm saying is when the communication is not kind of working, but you're still a court-appointed attorney, there are different rules, I think, for court-appointed attorneys to get out of a case.
Yes.
With a person with diminished capacity, and that's what I want to do. But look, we can't say they're unfit.
Yes.
And that is the whole case.
That is a difficult problem. So the issue is whether or not, if you're appointed to represent a child who, or a minor, I should say. I'm sorry, so the parent, if you're appointed to represent a parent, and the parents, the claim against the parent is the parent may be unfit to a parent.
Correct.
So you can't communicate that to the court. So I guess that leaves you in a more difficult situation, but I think not an impossible one. So the question is, to what extent can you get from the court extensions of time, and can you get treatment for your client?
You can't necessarily get out of the case.
You cannot necessarily get out of the case. Whether you can get out of the case as an appointed attorney is a complicated matter that depends on who the judge is and what the circumstances are. So some judges will let you out. Judges do let public defenders out of cases when they can't agree with their clients about what the
aims are. I see this happen. I do mental health cases that happen in the criminal court for weird reasons that I see all the time. Public defenders get up and the client fires them. And there you are. And the judge decides, says to the client, sometimes I will appoint someone else. Sometimes you either get the public defender or you don't, and the client is then put to this difficult choice by the judge. Okay, not so good, but that wasn't you, that was the client who fired you. It does seem to me if you can't do what the client wants, you should communicate that to the client first. And then if the client may tell you, well, I'm going to go and ask to have someone else appointed, and you can explain to the client that there may be negative consequences from that. That the client may believe, that the judge may believe that the client, that this is evidence of the client's mental illness, and you may want to communicate that to the client before she or he goes down that road. And then at the end of the day, you may be stuck representing this person, in which case you will simply do your best. But the question,
the difficult question for lawyers representing people with mental disabilities is always the interaction between the goals and the means. And so you may very well agree that the client can get this goal, but the client won't agree on your means. And you completely disagree with the client that if you pursue her or his means, that you will get to her or his goal. And it seems to me your job is to communicate that as clearly as possible to the client, to see whether you can get treatment for the client, to avoid disclosing that to the court if you can. And if you're stuck representing the client, I'm sorry.
Okay, thank you.
You have a question in the back then?
Mark, sometimes my experience has been to use the vague term of irreconcilable differences.
Yes, exactly.
And without putting the person's own population.
Yeah, that's Joe Monahan is suggesting that the phrase that you should use, which I agree completely is a nice phrase. You just have irreconcilable differences with your client. Again, that only works if you can get out. If you're appointed, you may not be able to get out. But that is, I agree completely. When you decide you must leave, if you can leave, it's perfectly, lots of lawyers and clients come to a parting of the ways. If you hang around courts enough, you see this in every kind of court. You will find a client gets up or a client and a lawyer gets up and they say, Your Honor, can we have an extension of time? There's going to be a new lawyer coming in here. We can't agree on this. And the judges make no assumptions about that in most contexts. Sometimes it's a dispute over money, right? The client doesn't want to pay you as much as you want to be paid, and you say bye-bye. And that's a perfectly legitimate thing to do. Yes?
I have a couple of times basically just stepped up and said, we have an impasse.
Yes, I think that's another perfectly fine word.
And, but
impasse is another word that's being suggested. I agree with that.
Always assume that it's a money issue. They do.
I think they do. In most contexts, they do assume it's a money issue.
So if you're like a bar, fine example, like I'm also a bar attorney.
Yes.
So where I've asked to step out, and the judge turns around and says, well, Mr. Dean, I'll just reappoint you as a bar attorney. The county will pay me. No, that's not the issue.
Yes. So the comment was that that sometimes when you're a privately retained lawyer and you advise the judge that you would come to an impasse or irreconcilable differences or you can't agree with your client, the court will assume that it's a dispute over money and may, in some contexts where a client has the right to a lawyer or the judge wants to appoint you, will appoint you as a bar attorney, and then you will be stuck back representing the client unless you can give some other explanation. But you can still go back to, we have irreconcilable differences or an impasse, and it's not money. It still could be plenty of other things. People can have legitimate disagreements with their lawyers about what the goals and the tactics of this litigation are that are not money and are not mental illness. Yes.
There's another thing I've done, I think that may apply to say having problems communicating with your client, which because of that is a violation of the rules of professional responsibility, certain rules of professional responsibility.
Yes, the comment was that you could state to the court, the tribunal, that you're having trouble communicating with your client. I guess that one sounds more like it might be mental illness, and while I agree with your comment that that is a legitimate basis for being excused from the representation, again, I would always say as little as possible and stay away from anything that gives any hint that my client is mentally ill. Maybe the judge will just assume that it's my difficult personality. That would be good if the judge assumes that, because that protects my client. But the judge may not assume that. He may assume it's a client. Yes.
In reference to the civil matters in the juvenile court, I think my experience is that disclosure of mental illness for my client is really an academic concept because of the liberal perceived ability of the state's attorney or whoever's prosecuting the case to access your client's mental health records. And I know we're going to talk about that later. But there seems to be this unfettered notion that they can access our client's mental health records, but oftentimes they're allowed to do that either by court order. So a lot of times the cat's out of the bag, at least in the sense that the diagnosis has been disclosed in evidence. So I just point that out. So I find that less of a problem because it's already there, but the bigger problem is arguing the correlation between the mental health. Now they know there's mental health, but does that really correlate to unfitness or whatever else they're trying to?
So the comment is that because of the lawyers on the other side, the prosecutors have access to mental health records, a topic that we have one of our foremost experts, Joe Monahan, will talk about that momentarily. I won't. The judge they may be able to introduce evidence of mental illness anyway. And of course, it's also true that judges who are experienced judges, like any other person, can detect symptoms of mental illness from clients and lawyers and anyone who appears in front of them. And the judge may very well already understand that your client has some kind of mental illness based on her or his behavior. There's not a lot you can do about that other than to make sure that the client understands that this may be happening, and suggest that as another reason it would be helpful to get treatment so that the judge begins to think better of your parenting capacity or whatever else is wrong. I think I'm being told my time is up.
Okay, so thank you so much. This was so helpful for all of us. We're going to take a 10-minute break at this point. We'll resume at 10 to 11. Thank you.
Okay, is that it?
Excellent, I think so.
Okay.
I'm very privileged to introduce our next speaker, who again is somebody who's one of the leaders in the mental health and health care law world. Before he became a lawyer, he was a social worker, so he brings both perspectives to his practice, which consists of, he's been in a number of settings, including when I first met him at the Guardianship and Advocacy Commission some years ago, representing people with serious mental illness. And since then, he has been a private attorney with Monahan and Cohn, and then Monahan Law Group, or law offices, where he represents people in all sorts of kinds of settings where mental health law comes into play. We have asked Joe to speak about confidentiality and records issues, and he has extensive juvenile court experience as well. So with that introduction, I'm very happy to introduce Joe Monahan to speak to us about the complicated issues that we face of access to records with clients who have mental illness.
Thank you very much for that wonderful introduction. You know, Diane Redleaf, as you all know, is a legend. And she and I have been working together for, I think, 3 decades at least. And it's been fun to watch Diane grow up and do the things, but she's always been so committed to these issues. I was telling Diane yesterday, I was at one of my clients, we represent about 70 hospitals throughout the metropolitan area. And we were talking about investigation of child abuse yesterday in the emergency department. And I said, why don't you bring in Diane to teach people how to do proper assessments on child abuse and to avoid some of the mistakes that we see time and time again. And I also would say that Marc Heyrman has singularly been responsible for much of the legislation regarding mental health. He too is just, I feel honored and humbled to be a part of this program with such great people. Barry Taylor, it's an awesome lineup of people that you have. Today, I would invite you to pick up one of the materials, if you haven't already, the PCFS View of the Records. And I think I'll just tell you a little more about my background so that you understand my bias. When it comes to records, it was drilled into me in my undergraduate and graduate career that the whole basis of a therapeutic relationship was confidentiality. And when I train physicians and psychologists and psychiatrists and social workers, which I do regularly, I give them one rule about confidentiality. And that rule is very simple. If anyone ever asks you for information about your client, just say no. Because as we're going to talk about this morning, the rules and regulations are very complex. But where I start is the relationship between a therapist and an individual is sacrosanct. People have an expectation of privacy, and they deserve it. And it is the root of all therapeutic intervention. People have an expectation of privacy. They want to have their private information kept confidential. And then we talk about the juvenile court. So the rule that I always tell my therapists and mental health agencies and child welfare agencies is just say no. Second, who's asking? Third, what's your authority to get it? Because as you'll see by the end of this hour, the rules are very complicated and confusing for therapists and for lawyers alike, and certainly for judges. We address these issues every day with our clients. And so today I want to give you some practical thoughts about how you as representing individuals in juvenile court can address these issues. So today I'm going to start off, this was supposed to be the basics. So we're going to talk a little bit about juvenile court proceedings. I imagine you all know about that, so I won't spend much time. And then we're going to talk about the protections the law provides for mental health and other records that get it. I have been in and out of the juvenile court over the last 30 years in various roles. The juvenile court in Cook County has changed tremendously because of litigation that Diane has brought and ACLU has brought and litigation that I've been involved in. You may know that there used to be only 3 GALs at the juvenile court, 3 GALs. And at that time, I think there were probably over 40,000 kids in the Cook County Juvenile Court. One person who's in this room saw fit that that was not ethical and made certain complaints, which resulted in a wholesale revolution in juvenile court, so that kids were able to be represented. That was a big change in the juvenile court. It used to be that state's attorneys went there, kind of got banished to juvenile court as a way, as they graduated from traffic, they got sentenced to juvenile court and they wanted to get out of there as quickly as possible. Same with judges. Judges were punished by going to juvenile court. It wasn't seen as a prestigious appointment. And now, for many of you who have been over there, you know that there's lots of state's attorneys and public defenders who have been committed to their career to a life in juvenile court, as well as some of the judges. That's a big, big change in the way that the juvenile court is operated. So let's just talk about some of the actors who are in juvenile court. The state's attorney prosecutes the case, abuse, neglect, dependency, and delinquency. The public defenders represent the parents who are accused of either neglecting or abusing their child. Sometimes we have conflicts, so private attorneys, the private bar is used to represent individuals who are parents or guardians. The guardian ad litem's office is often served as guardian ad litem for the minor. They represent supposedly the best interests of the child. Sometimes there can be conflict, particularly with older adolescents who the guardian ad litem is not only needed to represent the best interest, but also the views of the minor. Sometimes that conflict is irreconcilable, and so a different person has to be appointed for the minor to represent their interests. Less so in Cook County, but in many of the other counties, we see court-appointed special advocates having an important role in the juvenile court. Those are often non-attorneys who are appointed by the court to serve as the eyes and ears of the court. DCFS usually will have an attorney in the courtroom. Sometimes private agencies, our law firm or other law firms will come in and represent the private agencies, particularly when there's a dispute between the private agency and DCFS. Other public agencies or private agencies might be involved in the placement, particularly when you have a family with multiple children, different placements, different agencies, and oftentimes disputes. Sometimes the evaluators themselves will bring in lawyers. We are often called in to represent physicians or psychologists in heater cases. So at any one time, you can have 4, 5, 6, 8, sometimes more lawyers called to the bench when the case is called. And those are usually the cases which give everybody heartburn, and they have to be addressed. So it's important, as I tell the people who we represent, to understand the different actors and their roles so that you can figure out what's going on. In juvenile court proceedings, we start looking at evidence, and this is, in my view, where all the confusion starts. In the Juvenile Court Act of 1987, it says the privileged character of communication between any professional person and patient or client, except the privilege between an attorney and client, shall not apply. And so earlier the comment was made that parents have no confidentiality in juvenile court, and it's pointed the juvenile court ethos. The culture of the juvenile court is to have good exchange of information. Everybody needs to know everything about everyone, and that there is no confidentiality. Illinois Supreme Court Rule 907B says the children's attorney or guardian ad litem shall have access to all relevant documentation. And so this empowers the GALs to have access to as much information, because isn't it the way we look at the world that we're all working for the best interest of the children? And that phrase, in my view of the world, covers everybody's mistakes, because after all, we're all working into it. The statute and federal rules govern specific set of records and protect the confidentiality, which in most cases is more specific than this broad generalization that's offered in the Juvenile Court Act, or so we argue. It becomes a matter of statutory construction when you look at things and you say, hey, wait a minute, this statute was passed after 1987. Therefore, the legislature was on notice that this occurred, and they made more specific things, so we argue. And we have to assume, when we're doing our statutory construction, that the more specific act is going to override this general provision in the Juvenile Court Act. I'm going to stop there and see if anybody has any question or challenge about that, what I've said. Okay, I'll go on. The first stop is I want to talk about mental health records. And indeed, my view of the world is that the Mental Health Confidentiality Act was passed in 1979, along with the major revisions in the Mental Health Code that were made in 1979. First point, mental health records are not medical records. Second point, as it relates to HIPAA, everybody thinks HIPAA is a protective statute. I disagree. HIPAA is a notice statute that puts you on notice. Hey, everybody, you know that PHI, your private health information, we can use and share that information without your consent for treatment, payment, and operations. HIPAA doesn't protect us in the way most people think it does. But the Mental Health and Developmental Disabilities Confidentiality Act states all records and communications are confidential unless otherwise provided. Let me stop and say records and communications. The Confidentiality Act includes things that are said to people in the course of the therapeutic relationship. So therapists incorrectly assume if I don't write it down, it's not discoverable. Not true, because records and communications are covered by the Act. The Act has a very, very strong bias towards keeping all information confidential. And that's been repeated throughout various different cases. And we'll talk about Mandel versus Cannuli later. But I took the quote from there. It's a strong statement about the importance of keeping mental health records confidential. So the ethos of the Mental Health Confidentiality Act is all records and communications are confidential, which, as you can see, directly contradicts with that broader statement in the Juvenile Court Act. So, when can you reauthorize the release of information? Well, mental health records can be authorized by the individual whose records they are. So again, we start with this whole notion that if I have a mental health record, I don't want anybody to have access to it. I'm telling my therapist the deepest, darkest, most intimate and private thoughts about my dreams, my fantasies, my concerns. And I expect, if I'm a recipient of services, that that information will not be shared. So the therapists are said, don't say nothing to nobody about nothing, but the Juvenile Court Act is very different. So when can my record be disclosed? Well, if I provide a written authorization. I'm over the age of 12, I control my record. I can say this person can get it, this person can get it, this person cannot. People can get a proper court order, believe it or not, get access to my private confidential information. And then there are all sorts of exceptions. And we could spend the rest of the day talking about the exceptions to that notion that my private information is confidential. So let's look at a couple of those exceptions, particularly as it relates to juvenile court proceedings. All right. So let's talk about disclosures first of all. As practitioners, do not rely on HIPAA authorizations. I'll say it again. As practitioners, don't use HIPAA authorizations. Why? Because under Illinois law, HIPAA authorizations do not meet all the requirements of Illinois law. Friday at 3:30, we'll get 3 calls from lawyers demanding records from our facilities and screaming that HIPAA requires us to turn them over. The truth is, HIPAA has 3 areas where they fall short of the requirements of the Confidentiality Act. So let's talk about what the requirements are. An authorization has to be signed by the person who's entitled to inspect and copy a recipient's record pursuant to Section 4 of the Confidentiality Act. Who's entitled? The parent or guardian of a person who's under the age of 12. So for all children who are under the age of 12, the parent or guardian has the ability to sign an authorization that allows that child's record to be shared. Now think about that in the context of your juvenile court representation, particularly after a TC hearing. Who's the guardian? Who's the guardian of your child? Who? So the question is a parent the guardian? Is DCFS the guardian?
Not the guardian yet.
Query, as we say in law school. So if you're involved, which oftentimes you're not involved in the TC hearing, you want to think about who's going to have access to those records and who's going to have the ability to share that information. As just even the first, which seems to be done routinely, but really after the TC hearing, DCFS is appointed temporary custodian. Now in Cook County, I know that we've been a little more sophisticated because I've made those arguments over the years, as others have. And they also include what abilities that temporary custodian has. Ability to consent to treatment, ability to access records. But check your records, check your order that is entered, and see if it's strategic for you. Because the Confidentiality Act talks about parent and guardian. Who's the parent? Interesting cases on who is a parent, right? How do you show that a person is a parent? You've all been involved in putative father registries, probably. How do you evidence that I am the father of a child in Illinois? How do you do that?
Presumed or
established. If the person's married at the time that the wife gives birth, it's presumed that you're the father. If you register, it's presumed that you're father. If you're on the birth certificate, it's presumed that you're father. But look at those cases where a father is always presumed that he was the father, and then after paying child support for 12 years finds out, oops, I'm not the father, and tries to get out of continued child support. Well, the Supreme Court of Illinois has said, sorry, you said you were the father. You have been paying. You're going to continue to pay even though biologically you're not. So the point here is you don't have to be married. You have to have some type of establishment of paternity. And oftentimes in juvenile court cases, that's an issue. And the judge will order someone to take a paternity test. So parent or guardian is under 12, and you only need the signature of one. It's important for you to understand because oftentimes you're appointed to represent one or the other, and they may not have aligned interests. Knowing that you have the ability based on the parent that you're doing to get access to the child's records is an important thing. What's ignored by virtually everyone is that 12-year-olds have the right to control their record. It's ignored. It's inconvenient. We don't get their signatures. We don't get their authorizations. And interestingly, the law was changed way back when by DCFS because for those kids between the age of 12 and 17, it was very difficult to get access to records. We would always say, we're not giving you the information. So they couldn't get them placed because our kids didn't want to get placed. So DCFS changed the law back then and said, if a child between the age of 12 and 17 doesn't authorize the sharing of information, the parent or guardian can get this information, and I'll give that to you in a minute. Who else can have access? The guardian of the person who's 18 years of age or older. The Office of Public Guardian went in and changed the law to allow an attorney or guardian ad litem who represents a person 12 years of age or older, provided that the court has entered an order. A lot of times they don't get orders entered. Now on their appointment in Cook County, there's the language that says, and also has access under the Confidentiality Act. Foster parents do not have the authority to access confidential information, which is often presumed, and people share the most inappropriate things with foster parents, sometimes illegally. Grandparents do not have access. It's parent or guardian. Diane, you had a question.
Yeah. Are you aware of any law that discusses the coerced authorizations or circumstances in which the authorization that a parent might give is considered to be invalid for the purpose of
the question is, am I aware of any law that says you can't coerce people into authorizing access? It goes contrary to the notion of written and informed consent, that you're not supposed to coerce people. It happens all the time. And I assume you can make that argument. Juvenile court, of course, we all get involved. Oh, you don't want to release that information? Okay, we'll take your children. That becomes, there's the law, and then there's the reality. Yeah? Yes?
What we see downstate is that the DCFS or the private agency worker working with the family is presenting our clients, the parents, with blank release forms that are not specific whatsoever to the facility, the date range, the type of records, who can they be re-released?
Yeah, I'm going to interrupt you because that's actually our next slide.
Okay, great.
The comment was that people often are given blank authorizations seeking as much information as possible. And here's what Section 5 requires. If to do a proper authorization for the sharing of private information, you have to say the person whom the disclosure is to be made, the purpose, the nature of the information, the right to inspect and copy, the consequences of refusal, if any, the calendar date on which the consent expires, so that if that is left blank, which it often is, people think it goes in perpetuity. The fact is there is case law on that. If you leave that blank, it's only good on the date that the authorization is received by the person who's releasing the information. The right to revoke the consent at any time, which is a very powerful thing. You cannot, according to the statute, have a blanket consent. You have to specify the information to be disclosed. And unlike in HIPAA, it has to be witnessed. So under Section 5, there are 3 areas which are not required by HIPAA. The first one is the right to inspect and copy the information to be disclosed. So that's the 4th one. HIPAA also does not require a calendar date in which it expires. And the 3rd one is that HIPAA does not require it to be witnessed. So earlier when I said HIPAA authorizations are not compliant, is typically the HIPAA authorizations do not include those 3 things which are required by our statute. So when you take this black and white letter law directly from Section 5, it goes to Diane's point about coercion, and it goes to your point about blank things. Now, and if we look at DCFS's requirement under their policy guide in 2011.07, this is the directive to DCFS staff. And specifically, the DCP worker, if they find out that there are mental health issues, you go to that person and say, sign this authorization. That's the etiology of why you're experiencing this downstate. And this policy guide gives me heartburn when I read it because it's contrary to what the law is. So if I voluntarily authorize you to access my information, that's fine. But under this scenario, DCFS says, well, if you don't get it, go file a subpoena. And we'll talk about subpoenas in a minute. But this is the reason why DCFS and DCP workers are going after this. Now, understanding child welfare and understanding roles and understanding if you're doing an investigation of child abuse, it may be material, it may be important to understand a person's mental health issues, particularly their diagnosis in commitment explosive disorder, depression, suicidality. All of those things may be instrumental in what is going on in the case. It may lead to decisions to remove a child or what kind of other services would be needed to keep a child in their home. So I'm not at all ignorant of the fact that mental health information is important in their work in child welfare. I just want them to play by the rules. That's what I want to do. Okay? So this is the requirements for an authorization. And I've highlighted there are the three areas that are different than the HIPAA requirements. Let's talk about subpoenas for a minute. And this is where I've had all sorts of discussions with both the public guardian and the state's attorney of Cook, and where we run into problems all the time in accessing records. And these are real practical tips that you can use in representing parents. Under the Confidentiality Act that my friend Marc Heyrman and I have worked on for a lot of years, the notion was, how can somebody subpoena my mental health record? And how can a court, whether it be juvenile court, domestic violence court, civil court, enter an order turning over my mental health record without notice to me? That's ridiculous, isn't it? I think it is. And so what would happen is somebody would have a dispute with somebody, they'd subpoena their mental health records, and the next thing you know, their mental health records are being delivered to the court. So what happened in Illinois is we wrote the law to say, prior to getting access to my record, you have to give notice to me and my provider. And there has to be a motion filed. And you have to say that this record is releasable or obtainable for some reason, likely to lead to, it's probative, it's likely to lead to admissible evidence, it's relevant, etc. So this case that I cite, this 1998 case, Mandel's area, this is, these cases all usually arise out of domestic relations. And in this case, a woman goes into this local hospital. She's suicidal. She goes in and gets treatment. Somehow, the husband or ex-husband finds out about it and says, this is really juicy stuff. The lawyer sends a subpoena. The hospital in response to the subpoena, hops in the car, drives to the Circuit Court of Cook County, and places this woman's confidential mental health record on the judge's bench. And the lawyer then proceeds to introduce evidence of this woman's suicidality, and the judge in horror says, "You're right, custody should go to Dad." Marc was talking about the stigma of mental illness, and there's many, many cases sort of with the same thing. The law requires, hey, buddy, before you filed that subpoena, you had to go in and give notice to Mom. You had to give notice to the holder of the record. There had to be a hearing, and then you could use the records if the judge entered an order. You didn't do any of that. So Mom sued lawyer and hospital. The appellate court said, you didn't follow the rules. You, attorney, violated everything about this. Prior to issuing a subpoena, you have to give notice, you have to have a motion, you have to get an order from the court. And sanction the lawyer. For the hospital, I think they had a better lawyer. The appellate court said, well, you tried. At least you brought the record and the judge made a mistake, so we're going to let you off the hook, but held the lawyer accountable. So you need to give written notice to both the recipient of the mental health services and the treatment provider. Now, has anybody in this room ever experienced that with one of your clients in juvenile court? You have?
I wasn't a juvenile court case, but it was a domestic violence case, and I was representing someone whose spouse, had some mental health issues, and there was obviously a dispute about who was the aggressor. And I did file a motion for release of mental health records at the site, and the judge made a decision that she would view them
In camera.
So someone from representing the therapist came to court, and the judge reviewed the documents in camera, and ultimately said, I don't think they're relevant. But
okay.
That was,
so one of the participants here in the seminar said it not in juvenile court, but in domestic violence. And I will tell you that there's another layer of protection for domestic violence records. And what the person described was that the mental health records were requested, the judge did an in-camera review, and ultimately decided the records were not probative or would lead to admissible evidence or relevant for the purpose on there. Our experience is we get subpoenas from the state's attorney, the public guardian, the public defenders regularly, probably 3 or 4 a month. And we have a standard letter that we send on behalf of our agencies and say, Section 11010D of the Illinois Mental Health and Developmental Disability Confidentiality Act provides prior to issuing a subpoena for records, you have to obtain a court order, blah, 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 blah. So we have a canned letter that we do. We're not going to turn it over. Additionally, for many years, Marc and other members of our committee that review all the mental health legislation had put into effect, we were trying to get a Supreme Court rule that says on the subpoena, and we had difficulties getting that passed, so we just put it in the statute that says each subpoena for mental health records or communications must include the specific language in Section 11010D. I guarantee you, no subpoenas can include this language. So it's another area that you can use to object if they're trying to get your mental health records. Yes?
We have a question from the webinar. Does Manziara apply in juvenile court proceedings?
We're going to get to how juvenile court is different in just a second. Good question. The question was, does this case that I've cited apply in juvenile court? Hang on, we'll do that. The exception in juvenile court, which was done, I believe I can credit the public guardian's office for doing that. The exception applies when the recipient is named as a parent, guardian, or legal custodian of a minor. So if you have been named in a juvenile court petition as a parent, guardian, legal custodian, then there's an exception. You don't need to do this. And that puts you in a particularly difficult position. So for example, suppose my wife and I are accused of neglecting our child, but it's really my wife because I left, but I'm still named. Does that mean you can have access to my confidential information? Query. So if you're placed in that position, what are you going to do? Obviously, this is a big exception. Second question with this exception: how do I know who's named? Right? How are these juvenile court cases styled? In re Johnny Jones. My name's Timothy White. I'm Johnny Jones's father. How do I know that you have access to my records? How do they know that I'm the father, et cetera, et cetera? So although this exception applies, it's a question that you still have to probe. I probe when we get these things in the exception. We say, hey, public guardian, you don't have access. And they say, no, this person's been named. How do I know that? They're not going to give us access to the confidential juvenile court record, so we kind of go round and round and round. Because the exception applies to a person who's subject to the wardship alleging that the minor's abused, neglected, or dependent, or who is subject to the petition, supplemental petition, or motion to appoint a guardian with the power to consent to adoption. Yes?
I guess my question would be, with the exception of giving you the subpoena and respond, or you not the subpoena but the petition that actually states the parent's name, how else would one be able to prove that the parent is a party? I don't think that it's listed on the clerks for now.
Right, that's what I'm saying. The observation is, how else would you know that?
Yeah.
Without having access to the record. So I think this causes our office and the public guardian's office and the state's attorney's office to go around and around and around. I'm just putting it out there as a point of law that you may use in discussing who has access to the client's record. And who is the recipient? A person who's receiving or who has received mental health or developmental disability services. So it's a widely defined thing in the Confidentiality Act. All right, so when we look at this, the most common issues that we have is there's a form entered now in Cook County. They have a form order that's entered in the juvenile court proceeding, and we often see that it's entered without any notice to the therapist. And we have to say, well, we were in receipt of this order, but we didn't have any notice. And that always brings joy to the state's attorney and the public guardian or the public defender who's ever doing it. And for minors who are up to age 12, we say that the minor is the recipient. This exception doesn't apply because the recipient's not the parent, guardian, or local, or the legal custodian. You're trying to get access to a child's records. That exception doesn't apply. The Section 4A5 doesn't apply because the minor's not 12 years of age or older, and you either get an authorization signed by the parent or the guardian, or get a court order. And you can imagine that goes over real well, right? We're not going to go ask the wife or the mother of this child who abused this child for authorization to get after this kid's record. We're not going to go get an order because that's way too much. Who are you to tell us? So we always have these very interesting conversations, and then they send us an order, and then we say, well, you didn't give us notice. And then, so it goes around and around and around. They love hearing from us. So what we try to do is write a letter and say, here's what the law is. This is what we're looking for. Can you comply with the law? We didn't make up the law. There's a question in the back.
I noticed that you mentioned notice to the therapist. like, I know that there's some provision under HIPAA about the therapist notes, and I thought there was under the Illinois Mental Health and Developmental Disabilities Act. If they just give, like the subpoena is for the release, either one, are just to the agency, for example, and not to the therapist asking for their notes, are those to be released if they did not notice the therapist and the therapist was not mentioned in the release?
The question, you had 3 or 4 questions in the question, and I'll try to break them down. The first question that I think you asked, and I think the bottom line of your question is, if I, Joe, am the therapist, and the agency gets notice, say I work for Happy Valley Mental Health Center, is that notice to the therapist? And I would say yes. Well, if notice to the entity would be considered notice to me, the therapist. That's how I'd answer that. Now, you also asked about, which is an interesting question, you started off by asking about HIPAA and psychotherapy notes. So that's a different conversation that we can have. What HIPAA considers a psychotherapy note is different than I think what you were talking about, a personal note under the Mental Health and Developmental Disabilities Confidentiality Act. 2 separate things. So rather than, and that's I think beyond the purpose of our seminar, what you should know if you're representing parents and they're getting therapy, you should know something about personal notes because it may be a tool that you can use to keep private information confidential. I think that, again, might be beyond the our topic today, but if anybody has specific information about that, I'll try to pick it up at the end. Okay. When your client is a recipient, that's what this slide is about, and another party requests records from your client's therapist, you can have your client authorize a disclosure by putting in writing it's okay. And before the disclosure is made, my recommendation is that you find out what's in the record and whether that will be helpful or hurtful for your client. As was pointed out by another comment made earlier, any party may request an in-camera review so that the judge can go in chambers and she can look at what is in the record. The court can hold an in-camera review on her own motion. A therapist may assert a privilege on behalf of the client if the therapist believes that the disclosure would not be in the best interest. A court could limit disclosure, and a court may enter orders, protective orders, as they deem fit. These are all theoretical things, and that rarely happens in juvenile court in my experience. Why? Because the emphasis is getting as much information as possible so that the judge can make an informed decision. But these tools might be available to you under certain circumstances. When your client's child is the recipient, another party can request the records, so the GAL or another person. If the minor is under the age of 12, a parent or guardian can execute an authorization allowing the disclosure. You only need 1 parent. If the minor is between 12 and 17, the minor is supposed to authorize the request. And if there is no authorization, the requesting party can file a motion with notice to the therapist and to the recipient and obtain a court order. In my experience is that these orders are granted very easily and quickly. Drug and alcohol treatment has special protections, again, which are often ignored. In fact, the order that's entered now in Cook County includes reference to 42 CFR Part 2. I believe that the entry of those orders is not appropriate. because 42 CFR Part 2 has very specific procedures which have to be followed in order for somebody's record to be released. The notice provisions under the Confidentiality Act are not sufficient, in my view, under Part 2 of the rules. I never see anybody object to that, but it is a possible objection if you wanted to prohibit it. Now, I will tell you that we're back to square one where DCFS says, give me access to your treatment records, or this is what we're going to do. So practically, these are theoretical provisions in the law, and I rarely see them. Typically, we see people authorizing their disclosure. There's very limited exceptions, and it's very difficult to get a properly executed order. The other thing that's confusing under Part 2 of the rules is that they go to drug and alcohol treatment facilities, which are usually standalone, or if they're within a hospital, they're identified as drug and alcohol as opposed to mental health and drug and alcohol. Oftentimes, people are in the same facility getting treatment for both their issues of mental health and drug and alcohol. Making sense at all? You see? Okay. Yes, sir.
So we have a question from the webinar on the prior slide. Can the GAL make the request for a kid that is older than 12?
Yes. The question is, can a GAL make a request for a child who's over the age of 12? And that's when we started, or stated earlier, that the GAL has access to records and communications so long as they have a properly executed court order. Usually on appointment, the GAL appointment order includes access to confidential mental health information. I gave you a slide on drug and alcohol treatment authorizations. They're different than mental health, and I've given you the slide so that you can see it's very similar: the name, the individual, the patient, the purpose, how much and what kind of information, the signature, it's stating statement regarding revocation, and the date, event, or condition in which it expires. So it's very similar to our requirements. And I will also tell you, basically, there's no juvenile court exception under the federal rules, which means that disclosure technically for drug and alcohol treatment can only be pursuant to a lawfully obtained authorization or pursuant to a court order. And I'll pause just for a moment and say, why is drug and alcohol so rigorously protected? When this law was passed, drug and alcohol counselors, professionals really wanted information about treatment to be protected so that people could not use it against them. The idea is that you finally got somebody into treatment and you didn't want it made easily accessible by their employers, by law enforcement, to use the fact that they were getting treatment against them. So that's why we have a tighter control over drug and alcohol treatment. There is an exception for child abuse and neglect, but that exception is very narrow, and it's only for making the report, not for the access to the treatment information. So the exception does not apply to the disclosure or use of records in civil or criminal proceedings which arise out of the report of suspected abuse or neglect. Does that make sense? Okay. All right. Drug and alcohol, when you're seeking a court order, it's not for criminal purposes. A subpoena alone does not get you the information. The procedure and criteria in order to get it, you have to make application, you have to give notice, the court has to review the evidence, there has to be criteria for entry of the order and consent of the order. For many years, I've represented EAPs, employee assistance programs, For many years, we have told people, go get a court order. In the 28 years I've been doing this, I received one court order from a court in San Francisco where the U.S. attorney said, oh yeah, it's impossible to get a court order. I will show you. And that assistant state's attorney went in and went through all the steps. It took a couple of months after giving notice, after having review, but ended up with an order. Very different than the orders that we see in juvenile court, which say, pursuant to Part 42 USC or CFR Part 2, here's a court order. So it's, again, the culture is to get that information. The law is a little different than reality. Victim-sensitive interviews to CACs, the Child Advocacy Centers, is another area where our office sees a lot of action. The question is the CAC providing mental health services? And we go round and round about that. I've cited a case here in which the court entered a protective order to restrict the retention of a record. The public guardian objected to the portion of the protective order that said everybody had to return the CAC interviews to the court after the time for purposes of appeal. The public guardian said, wait a minute, we're the kid's lawyer. We need this. We maybe have to share this with other information. The appellate court said it was okay. It was within the province of the juvenile court judge to enter protective orders and enter provisions specifically. So it's a common argument, but that people use, hey, don't worry about it. The juvenile court records are not open to the general public anyway. The court said, sorry, we can enter such a protective order. The issue before was arisen about domestic violence. The domestic violence advocates have been zealous about protection of, and it's often, a matter of life and death, really. And so the Domestic Violence Act provides specifically that you're not supposed to use this information in courts. And I provided the citations to this. Any communication between an alleged victim and a domestic violence advocate or counselor includes all records by the domestic violence program in the course of providing. This goes directly contrary to what you would think in a domestic relations proceeding. It goes directly contrary to what you would think in a juvenile court proceeding. And it says it can only be disclosed in accordance with the provision of the Abuse and Neglect Reporting Act in cases where failure to disclose would likely result in an imminent risk of serious bodily harm or death of another person. We represent a couple of domestic violence agencies. We're always fighting this, particularly in domestic relations, child custody disputes. And again, the issue in juvenile court is, hey, we need to have this information. But people don't really think about the specific protections given to victims of domestic violence. So, in conclusion, there are records, drug, alcohol, mental health, domestic violence, that are specifically designed to be specifically protected. There are provisions specifically regarding the disclosure of that. We fight the exceptions that are provided in the juvenile court, and those procedures and protections for the court orders are often intricate, confusing, and depending on who's making the arguments, you have to do your best in presenting these arguments to the court. I think that's my time, right? I'm happy to stick around for any other questions that anybody has or challenges. Yes, sir.
Good question. HIPAA's been around for a while.
HIPAA?
When it first came out, we talked like it was going to change the world. Have there been any major changes to HIPAA in the years since it was initially put in place?
Um,
I know, like Illinois' Health Act has changed a few times.
the question was, HIPAA's been around for a while. Have there been any major changes? I think I have a whole separate lecture called the hoopla of HIPAA, because it's, I think on the good part of HIPAA is that it has risen to the notion of that people are more acutely aware of their privacy. But if you think about the purpose of HIPAA, the purpose of HIPAA is to enable the sharing of our private information. That's the whole purpose, to make it easier, to have more portability so that we can bill, so that we can share information. And if you were a part of our discussions in the recently enacted Health Information Exchange, where our goal is, some people's goal, is to put all of our mental health and our medical records in the cloud, so that if I'm in a car accident in Nebraska, they can pull down all of my information, so that my gynecologist knows what my cardiologist is doing, this one knows what, everybody knows what's going on. And doesn't that make sense for good medical care? But it kind of blows up my right to privacy.
Yeah, I mean, you can't even protect credit card numbers, much less.
Yes, so those are the issues which I think, and I think what, if I were trending, the trend is to share information within the context of the medical community. Marc Heyrman and I have had some very, very interesting debates about this, and where I think if Marc were still here, he would say, doesn't it make sense that we can all share information so that we can provide better medical care to the patients? And you have to weigh that against the stigma and disclosure of really protected information. So we didn't talk about HIV status. We didn't talk about AIDS. We didn't talk about genetic information. All of this stuff which is highly private. You know, your propensity to have certain illnesses like high SACS or other genetic related illnesses, if they show up on genetic tests, who has access to them? Who should have access? Should employers? Should insurance companies who are doing underwriting? You know, et cetera, I could go on. One, yes, another question.
I'm sorry. So Illinois Constitution has expressed right to privacy.
Yes.
My question is, how does anybody, I guess, reconcile that reality that the Supreme Court said that it's the same as the federal right to privacy, which you can't get on my cell phone. How does anybody look at that as a line gap with sort of the broad ability to do reports and just look at?
Yeah, the question is, hey, wait a minute, we have a constitutional right to privacy in Illinois guaranteed in our Constitution. And when you have these constitutional rights, and Diane can, get into the constitutional aspects probably much better than I, but there is a balancing test, right? And when you're infringing on somebody's constitutional rights, and I think in juvenile court specifically, we as a society have said, when balancing a child's right not to be abused or once abused, we're going to act in the best interest to make certain that we're going to make the best decisions that we can. So I think these things like confidentiality will often fall. That's where I would come up. Think you have a different idea? No. I think that's what the balancing comes up. In the I'll just give you one example. In the United States Supreme Court, the Jaffe decision, 1996, comes to mind. The Supreme Court was asked to decide whether social workers have a confidential privilege, a psychotherapist privilege in federal court. And there they said, yes, they do, but it's a balancing under certain circumstances. So even that was a balancing that the court applied. Yeah?
Well, my concern is that I'm talking in terms of pre-adjudication, before there's even been a determination of abuse and neglect, to be able to subpoena those records and then introduce them at the initial hearing. We can't even get to we don't even get to the best interest determination at that point, because we don't even know, the state's attorney believes there's been abuse or neglect, but it hasn't yet been proven. And if they have to rely on those private records to prove it, that, where's the balancing happen?
Yeah, and I think that you have the right to make the objections that they properly obtain those records to use, so that they're relevant, admissible, likely to allude to admissible evidence. That goes against the culture. So it's an interesting point, and just getting access to the record, as you saw by the DCFS memorandum, it's good child welfare to have that information. They're telling their people, go get them through a subpoena. My view is that they have to follow the law. Great.
Thank you.
Thank you very much for your attention.
So at this point, we're going to have our lunch break. We will resume at 12:45. Those of you who ordered lunch, we have lunch here. Otherwise, please be back at 12:45 for the next part of the afternoon part of the program. Thank you. I think this has been outstanding so far, and I look forward to more great presentations this afternoon. Center, who helped us put this program together and manage the logistics, and that's Brian Liberona, who's sitting up here in front, and Samantha Tarleton. So thank you so much. Now it's my pleasure to continue our star-studded lineup of presenters with the third person in the trilogy of leaders in the whole mental health disability field in our state, and really national leaders as well. And it's my pleasure to introduce Barry Taylor. Barry has been a civil rights and disability rights lawyer for many years. He is currently the Vice President for Civil Rights at Equip for Equality, where he's been an attorney since 1996. His bio includes many commissions, consultation positions, high-level leadership positions for the governor, and you name it. Senator Durbin, I think, was on your list. So many positions in which he's a real leader in the field of disability rights. So we have asked him to present today on the issues of parental rights in the Americans with Disability Act, civil rights generally, and issues of discrimination against parents based on disability. So I'm really looking forward to hearing from Barry.
Thanks very much, Diane, and thanks everybody for coming today. It's a pleasure to be here. I appreciate being invited. For those of you unaware, Equip for Equality is a private nonprofit organization that provides free legal services to people with disabilities. We're cross-disability, meaning we serve people with physical disabilities, mental illness, and also physical disabilities and developmental disabilities and sensory disabilities. And we're statewide. Most of our folks are here in Chicago, but we also have offices downstate in Springfield, Moline, and also in Carbondale. And our legal work is really focused on legal issues that are related to the person's disability. So we would not handle a person who is seeking a divorce and just happens to have a disability. Instead, we'd be focusing on issues where the issue that they're raising with us directly relates to their disability. So we do a lot of special education work on behalf of kids with disabilities to make sure they're included and with the supports they need to be successful. We do a lot of work on behalf of people in institutions who want to live in the community. We do a lot of work around abuse, neglect, We also do a lot of work in the probate arena on behalf of people with disabilities who don't believe they need a guardian and want us to either remove a guardian or help to prevent a guardianship from being imposed upon them. And then we do a lot of work around the ADA and traditional discrimination and civil rights, which we'll be focusing on today. Frankly, we do not do a lot of criminal rights work, and that's not my expertise. So I'll rely upon you to correct me if I say anything wrong or if there's some issues that maybe I miss. But hopefully I know about how the ADA works and how it can be applied to the context of criminal rights and family law. And hopefully together that synergy will work in this conversation. So for those of you who aren't familiar with the ADA is actually divided up into different sections called titles. And we're going to focus on one of those titles today, but I just wanted to give you how it fits into a larger piece of the legislation. So Title I of the ADA covers employment, both private employers that have 15 or more, as well as public employers. Title II, which is what we're going to be focusing on, addresses the services provided by state and local government entities. And Title III covers private businesses that are open to the public. Title IV covers telecommunications. And then Title V, which is sort of the forgotten title of ADA, but can be really important, and might be important in your work, is called the miscellaneous title. Maybe that's why it's forgotten. But within that title is that people with disabilities have a right to private right of action with regard to retaliation. So if somebody's retaliated for exercising their ADA rights, that is a separate cause of action in and of itself. So a good example of that is that in the employment context, if somebody asks for a reasonable accommodation and they're denied that, and then they file with the Equal Employment Opportunity Commission, the EEOC, and then somehow have some sort of adverse action after they file to protect their rights, because they're exercising a legal right and they are retaliated against for exercising that right, that's a separate cause of action from the failure to provide the reasonable accommodation. And so this could also come up in the family law context where somebody asks for some sort of accommodation, they file a complaint, and then they're retaliated against for exercising their rights. They would have a right under Title V of the ADA, and that can be brought in conjunction with rights under the other parts of the ADA. Oh, and I didn't say, if people have questions as we go along, feel free to raise your hand. We'll be happy to answer those, or those of you who are watching the webcast. We'll also save some time at the end for questions. So first, we need to sort of figure out what entities are subject to the ADA. And as I said, we're going to be focusing on mostly Title II of the ADA today, which provides protections from discrimination by state and local government entities. And that would include both DCFS as well as the courts, because those are probably the two arenas where you're going to see potential discrimination against your clients. And the Supreme Court helped us out a few years ago in a case called Tennessee versus Lane. And this was a case, really compelling case involving a couple of people. One was a woman who had used a wheelchair, and she was a court reporter, and she couldn't get to the courtroom on the second floor to do her job because there was no elevator in this courtroom, only the stairs. And then another gentleman who was actually a criminal defendant, and he couldn't get to the courtroom either because he used a wheelchair. And when he didn't show up for his criminal court proceeding, he actually got held in contempt and was ordered to be put in jail for failing to show up, when the reason he didn't show up was because he couldn't get there. And they said, well, the state of Tennessee, in their argument, one of the worst arguments you're ever going to see, said he could have, crawled up the stairs, and so he could have gotten there. And fortunately, the Supreme Court, even in its conservative nature that we see sometimes, rejected that argument and said that was not a basis. But the reason that case went up was not only whether that they had been discriminated against, but it also went to the issue of sovereign immunity, whether you could sue a state for monetary damages for failure to access the courts. And the court said yes. So, in the 11th Amendment, generally states have sovereign immunity, but if you can show that the statute allows the possibility of getting money damages and that there's sufficient legislative history and all that stuff we learned in law school, you can show that you could get money damages. So not only under the ADA can you get injunctive relief, meaning you want to get some sort of change, like an accommodation, you can also get monetary relief under Title II with respect to the courts if there's been discrimination. The thing that the Supreme Court didn't help us out with was they limited that case just to courts and left open what all other Title II entities. And so we have tons of lower court decisions going all over the place saying, yes, you can get damages, or no, you can't get damages. There's there's sovereign immunity, there isn't sovereign immunity. So the Supreme Court gave us some guidelines about, is it a fundamental right, and those types of things. Is there historical discrimination? But didn't really give us a strong guideline as to how this doctrine is going to be applied beyond the court system. So for discrimination by, say, DCFS, we don't have clear precedent and certainly don't have a Supreme Court decision to say that you would be able to get monetary damages, although you could still get injunctive relief. The companion for Title II and ADA cases is what's called Section 504 of the Rehabilitation Act. And for those of you who aren't familiar with that, that was an act that was actually passed in the 1970s, which said that recipients of federal funding cannot discriminate against people with disabilities. That's what Section 504 is. It's a section within the broader Rehabilitation Act that just focuses on discrimination against people with disabilities. And so that was really the very first federal civil rights act we ever had on disability with Section 504. But as I just explained, it's limited because it only applies to entities that receive federal funding. So for instance, private employers would not be covered by that. However, because DCFS and our courts do receive federal funding, they're going to be covered within Section 504 as well as under Title II of the ADA. And they really have parallel provisions. And so typically, if you're covered by one Section 504, the protections you're going to get are similar to those that you're going to get under the ADA, a few minor exceptions. Okay. So now we need to figure out if your client is covered by the ADA. And this sounds like a simple proposition, but unfortunately it's gotten rather complex. So I want to spend a little time explaining this because this is an important concept to get your arms around. So as I said, the Rehabilitation Act was passed in the 70s, and then the ADA wasn't passed until 1990. So I wanted to start first with the Rehabilitation Act because that's sort of the core starting place that we have. So the Rehabilitation Act defines disability in a three-pronged manner. So the first prong of the definition of disability under the Rehab Act is a physical or mental impairment that substantially limits a major life activity. Okay? And if you look at that, that's called the actual disability prong. And if you look at that prong, there's actually three components of it. You have to show that you have a physical or mental impairment. Okay, so people with mental illness would fall under that. That substantially limits, what does that mean? One or more major life activities. So really you have to prove three things: that you have a physical or mental impairment, and that you have a major life activity that has some sort of substantial limitation of that major life activity. The definition is actually broader than the actual disability. It has two more prongs. The next prong is a person has a record of disability. And what that means is that they have had some sort of past impairment, but they currently aren't impaired, but are treated differently or are discriminated against because of that past impairment. Let me give you an example. So let's say you're a person who had cancer, you've gone through chemotherapy, treatment, whatever it is, and you've been declared by your doctor to be cancer-free. Then you apply for a job, and you're not hired because the employer is concerned, well, the cancer may come back, they may miss a lot of work, or they may raise my insurance rates, or whatever reason it might be. If you're discriminated against not because you're currently impaired, but because you have a past impairment, and that's the basis for you being treated differently, that's the basis for the adverse action, you're covered under the ADA, even though you don't have an actual impairment right now. And then the third prong of the ADA definition, or the disability definition, goes even broader. And that says that if you are even regarded as having an impairment that substantially limits a major life activity, you also are covered by the ADA. And that can come up in a couple ways. One way it can come up is you can be regarded as having an impairment when you have no impairment at all. So let's say somebody just spread a rumor that you had HIV or AIDS. And that wasn't true, but they just assumed you did based on whatever. If you're treated adversely because of that rumor, even though it's not true, but they regarded you as having that, and there was an adverse action because of that misperception, you're covered under the ADA, even though you have no impairment at all. Also, if you have some kind of impairment, but it doesn't rise to the level of an actual disability in that first prong, your impairment does not substantially limit a major life activity, but you're still treated differently because of that perception that you're more impaired than you actually are. Let's say I have a slight case of high blood pressure, and somebody says, well, high blood pressure, wow, that's really, he's going to have a heart attack in my workplace. We don't want him around. We're not going to hire him. even though I couldn't prove they have an actual disability with the high blood pressure, because maybe it doesn't rise to the level of having a substantial limit of major life activity, because that perception is that I have one, that's enough to be covered by the ADA. So as you can tell, it's a very, very broad definition. And in fact, the Supreme Court in a very famous case involving tuberculosis called School Board of Nassau County versus Arline specifically said that the Rehab Act definition of disability is very broad. And what we saw from the 70s all the way up till 1990 is incredibly few challenges as to whether somebody was covered by the law. It was sort of almost just presumed. You would say, I have a disability, and then you would just, the court, oftentimes you look in these cases, they don't even talk about any kind of analysis whether you have a disability or any kind of argument on the other side that you didn't have a disability. They go on to the discrimination. So let's fast forward now to 1990. Well, in 1990, things changed because we now have the ADA, which is much broader than the Rehab Act, obviously, because it's not limited to entities that receive federal funding. It encompasses a whole bunch of entities, including private employers. Congress said, well, we've got this great definition of disability from the Rehab Act. Let's just use that for the ADA. Made sense. It's been working. Courts have been utilizing it. People were used to it. Made sense. However, the courts ended up taking an incredibly narrow view of the definition of disability and who was covered by it. And, a lot of people have different theories as to why that is. The conservative judges that have been put on during the Reagan administration, or perhaps now you had private employers that were covered and their private attorneys were like, wait a second, we don't want to be covered by this law. Let's hit them off the path. Let's say they're not even covered, and then we won't even have to show that there was no discrimination, because if you can't show you have a disability, you don't get to the next question of discrimination. And so every case that was filed almost, you saw some sort of challenge. Does this person really have a disability? And if they won on that, the case was over. And so you saw hundreds and hundreds of cases being dismissed. And what made things even more difficult was the Supreme Court was sort of the leader in this. They had a couple of cases that they decided that were incredibly difficult for people with disabilities. The first one is called the Sutton case, Sutton versus United Airlines. And that was a case that was brought on behalf of two women who were actually twins, and they wanted to be global airline pilots. And they actually had some visual deficiencies. They saw 400 without their glasses, but when they wore their glasses, they could see 20/20. So they had corrective vision. But United said that you can't be a global airline pilot unless you have 20/20 vision corrected and then 2100 uncorrected. The theory being, I guess, that if you're up on, flying that plane and something happens to your glasses, you can see well enough to, see the outlines of the runway and get the plane down. Sure, a perfectly reasonable policy. So they weren't hired, saying that they didn't see well enough to be covered as global airline pilots. So they've been sued under the ADA, saying they would be discriminated against. And United then said, well, you didn't see well enough to be a global airline pilot, but with your glasses, you see 20/20, so you are not substantially limited in a major life activity. You are not a person with disability. So they didn't hire them because they didn't see well enough, and then they said you're not covered by the civil rights law because you see too well when you take into account your glasses. And so what came up before the court was, is the issue of whether or not you're covered by the ADA, do you look at people with a mitigating measure or not? In this case, with glasses, but think of other mitigating measures people use, like a hearing aid for somebody who's deaf, or prosthetic leg for somebody who's lost a leg, or a wheelchair for somebody who's mobility impaired, or for our purposes today, somebody who's medication to address the manifestations of their mental illness. All the lower courts said you don't, except for one, said you don't look at people in their mitigated state, look at them in their unmitigated state, how they are unmitigated in determining whether they're covered by the law. And the EEOC, the Equal Employment Opportunity Commission, and the Department of Justice, which have regulatory responsibility under the ADA, said the same thing. But the Supreme Court said no. We think you should look at people in their mitigated state, and in their mitigated state, a lot of people aren't going to be covered by the law because they're no longer able to show they're substantially limited in a major life activity. And therefore, you put people with disabilities in this terrible position of sort of catch-22. Do you address the manifestations of your disability, or do you, seek to enforce your rights under a civil rights law? And so this was a terrible situation, and it just, what was horrible about the case specifically is, you can argue back and forth, were these people with disabilities or not? Does that mean everybody wears glasses covered by the ADA? And if you look at the Supreme Court at the time, Every single one of those folks was wearing glasses, so maybe they didn't want to even be associated with the ADA. I don't know. But the problem was they didn't limit the case to glasses. They said any mitigating measure. So it went really way broad. And then right after that case, the first case was decided by Justice O'Connor, and then another case decided by Justice O'Connor, Toyota versus Williams. The court said, and the facts of that case really aren't important, but what the court said in reaching against the plaintiff in that case is the definition of disability should be interpreted strictly to create a demanding standard. Now, those of you who are familiar with other civil rights law know this is very contrary to how courts have typically interpreted civil rights laws. So the civil rights laws from the 60s, there's great precedent that says that civil rights laws should be interpreted liberally to effectuate an important purpose. But here you had a court saying this civil rights law should be interpreted very strictly, and we should create a demanding standard to get in. And so as a result, as I said, hundreds and hundreds of cases got dismissed because plaintiffs couldn't meet the definition of disability, and they never even got to whether there was underlying discrimination again. Finally, Congress said this has gone too far, and in 2008 they passed a law called the ADA Amendments Act, or the ADAAA. And what they said was, Congress, you got it wrong, okay? Excuse me, courts, you got it wrong. We didn't want you to interpret the ADA so narrowly, and they rejected this whole reasoning in Sutton and said, we want you to look at people without their mitigating measure and determine whether they're covered by the ADA. And then once they get past that, you can look at them in their mitigated state to see if they're qualified for services, qualified to do the job, whatever it is under the ADA. So you have to be a qualified person with a disability. And they said, we don't like this narrow view. We want it to be interpreted very liberally and broadly. And we want you to spend more time on whether there's been discrimination and less time on whether somebody's covered by the law. And what's been great is that courts have actually listened. And we see a lot of cases, including many in Illinois, where cases that would have lost, people wouldn't have been able to show they're covered by the ADA, are now being covered by the ADA. And the courts are deferential to the Equal Employment Opportunity Commission's analysis and the Department of Justice's analysis when they weren't before. Congress made that clear that they do have the right to interpret the definition of disability. So it's a real sea change. And the EEOC has gone even further and helped out people with disabilities and specifically mental illness with some additional information. So there are no per se disabilities on the ADA. You still have to affirmatively put on evidence to show that you have a substantial limitation in major life activity. But what the EEOC said is, let's be real here. There's a lot of impairments that should easily be found to be substantially limiting. And we want to give you a list. It's not an exhaustive list, but a list that'll make it easier for courts to figure out, is this somebody who should be clearly covered by the law or not? And if you look at this list, and on the PowerPoint, it's in red, those last 5 bullet points are all different types of mental illnesses. So you've got major depressive disorder, bipolar disorder, post-traumatic stress disorder, obsessive compulsive disorder, and schizophrenia. That really covers sort of the major mental illnesses, I think, of the clients that you're working with disabilities, with mental disabilities. And so this is something that a lot of courts have looked at and relied upon in cases. And so that's something that's been favorably viewed by courts. The EEOC also went further, and one of the problems that people had in proving that they had a disability under the ADA is they couldn't, oftentimes people would have episodic manifestations of their impairment. So for instance, people with mental illness, a lot of times they're more acute than other times, maybe because they're in therapy, or maybe because they're taking their medication or not, or maybe just because of the nature, the cyclical nature of the impairment of the mental illness. And what would happen is, if they weren't substantially limited at the exact time of the adverse action, courts are saying, well, you have to be substantially limited in major life activity right when the adverse action happens. And if you're not covered, even if you might have been substantially limited the day before. And it was this very exacting standard that prevented a lot of people because of the cyclical nature of their impairment. And so what Congress said is, we don't agree with that. All that matters to us is, would they be substantially limited in major life activity when their impairment is active? And if they can show that, that's enough. And so the EEOC affirmed that in their regulations, and then in the appendix, they went even further and said, we want to give the courts more guidance and give them a non-exhaustive list of impairments that may be episodic. And you'll see that last group say psychiatric disabilities such as, and then they give those same impairments we saw before, major depressive disorder, bipolar disorder, schizophrenia, and PTSD. And we're seeing courts, again, rely upon this when somebody does have sort of an up and down type of impairment. And so the bottom line, or the punchline, so to speak, is that it's much, much easier for people with disabilities to prove they have a disability than before. Much easier for people with mental illness to prove they have a disability than before. Whether they take medication or not doesn't matter. And so there's no disincentive, at least from a civil rights standpoint, for people to not take their, to take their medication. All right, so what are the responsibilities of a state and local government covered under Title II of the ADA? Basically, it says that Title II says that government entities are prevented from discriminating against people with disabilities in their programs, services, and activities. Those three words are really important. Programs, services, and activities. You're going to see that in some of the case law we're going to talk about. And there's really two components of Title II. First, public entities cannot provide an unequal opportunity to participate in their programs, services, and activities. So that's sort of the typical equal access kind of component. But Title II goes further, and the ADA goes further in other sections as well. And that is that they must make reasonable modifications in their programs, services, and activities to ensure equal participation. So Congress said it's not just enough to let people in, to not discriminate by excluding them. You also have to affirmatively provide, under Title II, reasonable modifications of the services, programs, and activities that you engage in. Now, the term reasonable accommodation might be the term you're more familiar with, and that's under Title I for employment. Reasonable modification is the same concept. For some reason, they just used modification under Title II and accommodation under the employment provisions. But it's the same sort of thing, making some sort of change that will allow people an equal opportunity. And that change could be a physical change, so maybe making your services accessible to people with physical disabilities. It may be a change of communication by providing somebody with a sign language interpreter, or providing for someone who's deaf, or providing maybe alternate formats for people who are blind, or for people with mental illness, maybe changing some timing issues that they're having a hard time meeting, something like that. So it's some sort of affirmative change that they need to make. Now, what's important to always counsel your clients on is their responsibility to request the reasonable modification. A lot of times what we'll see is people say, well, I thought they knew I needed one. Isn't it obvious? And courts are pretty strict and say that it is the person with the disability's responsibility to ask for modification. Now, they're not the only one who has to ask for it. I mean, you can have a family member ask, their attorney can ask. Anybody can do that on their proxy. It doesn't have to be the person with disability. So if a person with disability is in the hospital and they can't communicate with the entity that they're trying to get the modification from, that's okay. And there's no specific requirements on how you communicate your request for reasonable modification. There's no requirement that it be on a certain form. There's no requirement that it be using the magic language, reasonable modification. There's no requirement that it even be in writing. We always tell people, though, and you should counsel your clients as well, is do put it in writing, because then you have proof, you have a copy. Do use the magic words, reasonable modification, because then there's less ambiguity as to what you're asking for. If they do have a form, use their form, so they can't claim that you didn't follow through. So even those things aren't required, they're best practices, and they're the best way to prove your case in court that you did ask for a modification, that you did follow the appropriate procedures. There should be no ambiguity that that's what you wanted. Okay? Now, sometimes people with disabilities don't know what they want or what they need. They just know they need some help. And so courts have said that you don't have to know specifically what you need, and if it's not exact or specific enough, it doesn't mean that you don't get an accommodation or that you didn't request one. It's starting what's called an interactive process. So once you initiate that, that's when the burden shifts over to the public and state and local government entity to engage in a discussion. Okay, you've asked for this. That doesn't make sense because of this, this, and this, but how about that? And what the courts have said is you're not necessarily entitled to your the accommodation or modification you've requested. You're just entitled to an effective one. So the old example is, you can request a Cadillac, but if a Buick works, they only have to provide with a Buick. Okay, so that's just, that's part of the interactive process, and they're supposed to talk to you and certainly take into account what the person with a disability wants, because they know their own disability, they know their own body, they know their own mind better than anybody else. But as long as what's provided by the entity is effective, that's all that's required. And so then the question comes in, was it effective? And that's where some of the litigation can arise. And so let's move on to the next issue. And there have been some cases that talk about the ADA, and I'll get to the major Illinois case in the next slide. But the first case talks about how reasonable modifications to services have to be provided to people with disabilities, parents with disabilities, to provide them with an equal opportunity, sort of showing that the ADA applies to parental rights. Then we have the case out of Texas that gives an example of failing to provide a reasonable modification to reunification services to assure that effective services were provided to a parent with schizophrenia. And then this case, the matter of John D., is an important case, although it's not in Illinois, so it's not that helpful to us, but it's an important case because basically what it says that in a case involving a termination of parental rights, the ADA does apply, and that it is considered a program, service, or activity. Those proceedings are. Now, in that case, unfortunately, the plaintiff lost, but what the case is important for is it shows that the ADA does apply to termination of parental rights proceedings, despite the argument that it didn't. Well, that's a positive case. Unfortunately, the news is that most courts go the other way and have found overwhelmingly that ADA claims for people with disabilities, especially in termination of parental rights cases, are not successful, and we'll talk about why that is. And I think the case that we have here in Illinois, INRI SR, did anybody work on that or know about that case at all? It might be yours? Okay. It's a case out of Peoria? Yeah. Does that sound like yours? Okay. Well, please correct me if I misstep on anything, or if you want to add anything to the case. I'm obviously just going by what I read in the opinion. But this is involving a mom who had schizophrenia, and at least my understanding from the court decision was that she'd been residing in a nursing home pretty soon after she'd given birth. And so she had not really had much time at all with her child, and the child was actually placed with a foster parent, and the foster parent actually already had this child's sibling and adopted that sibling, and were seeking to now adopt the new child and terminate the parental rights of the woman with schizophrenia. And the state had an expert that went in and met with her and found basically, that there was no way she could ever become a parent. It was very sort of cut and dry. She's sort of beyond hope, that she had a flat affect. She didn't show she was more concerned about her smoking break than she was about her kids, was the perception of the expert. It was a very damning expert's report that basically said there's really no hope here, and this child really needs to be with the foster parent. They need to become the parents, and this parent needs to lose their parental rights. And so she ended up suing, the case went on, and she lost in the trial court, and she appealed the finding of neglect and terminating parental rights, and included an ADA claim. And what she had asked is a reasonable modification. And again, the challenge here was the reasonable modification was asked for very late during the termination of parental rights proceeding when that got started. What she asked for, instead of terminating parental rights, you should appoint a guardian and give me some time to get better, but don't make this extreme decision of terminating parental rights. And the court looked at some precedent in other states and did a very cursory analysis, at least in the opinion itself, and said that the termination of parental rights is not a program, service, or activity, and therefore Title II doesn't even apply. And so there's no basis to bring a Title II claim. They're not really doing, this is not a service, activity, or program. Certainly some things leading up to the proceedings for terminating parental rights would be considered a service, activity, or program, but the proceeding itself is not covered by Title II. And so it took a sort of very narrow view of the ADA and looked at this specific situation and said, when we're talking just about termination of parental rights proceedings, those in and of themselves are not a program, service, or activity. ADA doesn't apply. And then, of course, to add salt to the wound, they said even if the ADA applies, there's no discrimination here because the expert's report was valid and there was no discrimination against the mom. And then, of course, they went to sort of the more traditional analysis of parental rights cases and found that all considerations of the parent here yield to the best interests of the child. And the best interest of the child, according to the court and according to the state's expert, was for parental rights to end and for her to be adopted by the foster parents. And so what's challenging here is that this is a case, obviously, that some pretty tough facts, given at least perception of the status expert of where this mom was. And so, but because of sort of these facts, I think we have sort of an extreme ruling about the ADA's application that will sort of, I think, implicate all future termination of parental rights cases in Illinois. It's an appellate court district, so you could argue in another district, I suppose, that they should take a different view. But of course, if there's no other precedent, it's going to be one that would at least be viewed as having persuasive authority. We were hopeful that in 2006 that the Supreme Court might help with this issue. So because of the bad case law that's out there, and it's been out there for a long time about the ADA's application, there was hope that the Supreme Court might clarify, because there are some cases going the other way, so there's conflict in circuits, which is sometimes a basis for the Supreme Court to take a case, and to hopefully reverse a lot of these bad cases around the country. So there was a case out of Rhode Island called Irving Inn versus Rhode Island, Department of Children and Youth and Families, where a very similar kind of scenario to the Illinois case I just mentioned, where they found that the mom had been abusive and neglectful, and that therefore that her ADA claim was not valid because the termination of parental rights proceeding was not a service program or activity. And so what they did was they petitioned the Supreme Court to try to change this. And as you know, the Supreme Court's review of cases is discretionary, and they turned down a lot of cases, and unfortunately they turned down this case. So by turning down this case, it sort of left in place the lower court precedent, and now we have the 2014 case in Illinois that would be consistent, has not been overturned as well. And the argument here was this is inconsistent with the plain language of the ADA, and that you're taking too narrow a view of what's considered a program, service, or activity. But also, there's a really good Supreme Court case on Title II called Pennsylvania Department of Corrections versus Yeski. This was a case that was brought in the late 90s, one of the first Supreme Court cases under the ADA involving prisons. And what happened here was you had a prisoner who had not been accommodated to participate in one of the prison programs. And the prisons folks said, wait a second, prisons aren't covered by the ADA. When we're talking about program, service, and activities, it's about like people with disabilities going to the park and park district programs and things that people want to go. People don't want to go to prison, and so these aren't really program, services, or activities. But the Supreme Court, in a unanimous decision written by Justice Scalia, which is unusual, actually found a very progressive view about the ADA and said, wait a second, prisons do have programs, services, and activities. And therefore, they are covered by Title II of the ADA. And they talked about that there really are no exceptions under the ADA under Title II, especially when those services implicate some sort of strong state interests. And so the argument for the Supreme Court to take this and reverse these bad case law was Yeski says that Title II should be interpreted broadly and should encompass not sort of only the traditional services program activities, but really anything a state and local government does should be covered by Title II, including a termination of parental rights proceeding. That should be covered. And unfortunately, because the Supreme Court didn't take the case, they didn't have the opportunity to expand their analysis under Yeski to apply to parental rights cases. And so that was a really unfortunate thing that happened. So what we have now, yeah, sure, question.
I'm sorry. Do you know if anyone has used the ADA to show that the services provided weren't available? Instead of saying whether the termination of parental rights was itself a service, whether the services provided weren't available.
Right. So the question is, has anybody used the ADA to show the services aren't available as opposed to just the termination of parental rights? And I don't know that there's reported cases, at least not in Illinois, on that, but there is some arguments that I'm going to get to on that exact point. So if you just hold that thought, I think I'll get there. Okay, great question. All right. So because the case law is bad, at least especially on the termination of parental rights, I wanted to just think about how can you use the ADA before you get to that litigation stage when things are pretty tough under the case law, and use it earlier when it maybe could be helpful for your client if you're giving people guidance before it gets to the litigation stage. And I want to give credit to the Bazelon Center for Mental Health. It's a national organization that specializes on mental health. They have a lot of information about parental rights, and so a lot of the strategies that I came up with, I wanted to give them credit because these are from a lot of the stuff that they've thought about, because as I said, I don't really practice in this area, so am borrowing liberally from their thoughtful guidance on this issue. So one of the things the Bazelon Center says, and I think makes a lot of sense, is it's really important to raise any kind of reasonable modification request early, okay? So if you need some sort of modification in the family preservation services, maybe at the time of removal, if you need those under the ADA, they should be raised as soon as possible for a number of reasons. One is waiting to raise them at the termination proceedings has been deemed too late by courts. And then, as we saw in the Illinois case and the other precedent, some courts have said that termination proceedings, by the inherent nature of them, aren't program services and activities, and so you're not going to get it no matter what. And then third, and this is more of a practical thought, is the longer the child has been removed from the parent's home, the more reluctant the courts are going to be to order additional services. So at the time of any kind of problems that are arising, or at the time the person is interfacing with the DCFS or any kind of child welfare systems, that's when they need to ask for the modifications. That's when they need to show that they need some sort of assistance to fully comply with whatever requirements are being put in their service plan. It's waiting until things have got extreme and they're moving to terminate parental rights. Most courts are going to say that's way too late. And so raising modifications early is really important. Another thing that Bazelon Center recommended is possibly bringing your own ADA lawsuit. So typically what happens in these cases is instead is you usually would raise the ADA issue as an affirmative defense or as a counterclaim. And what Bazelon said is, well, maybe there's a way to do this differently by going to the federal court and doing a sort of your own separate ADA case saying that accommodations weren't provided. And the federal courts are more familiar with the ADA and trying to raise them as an affirmative defense in the family law courts or as a counterclaim is going to be maybe a little trickier. The problem with that that they identified that makes sense is one is you've got some procedural problems here. One is the whole risk of abstention, which is the doctrine of which allows a court to abstain where the federal court claim would interfere with the ongoing state proceedings. So if you file a separate ADA case while the underlying state court claim is proceeding, a lot of times federal courts are going to say, wait a second, we're not going to do this while there's something else going on in the lower court, in the state court, so we're going to abstain from acting here. And so a lot of times when people file this separately, those claims get the courts refuse to move forward while there is a pending state court claim. But then you get caught the other way, and that is if you wait until the underlying state court claim finishes and then you want to file in federal court, then you've got issues of subject matter jurisdiction, and you've got issues of collateral estoppel and this whole concept of the Rooker-Feldman doctrine, which says you can't seek sort of federal review of the state court determination. That's not really the role of the federal court, or when there's claims that they use this term under the Feldman case, inextricably intertwined with the state court determination. And so that's been another way that ADA cases have short-circuited in the federal courts. Diane, you had a comment?
Well, I just wanted to make a general comment that this is a general problem with civil rights cases, period. But cases that involve intact services and cases that involve safety plans and cases that involve services generally that do not get tied into the juvenile court have been available for civil rights cases, and we actually filed one that is pending right now with sustained ADA claims. So,
so showing that what you have is separate from the underlying.
There's no juvenile court case in that case, so, right, but so there is state involvement. So. Right.
So if you can sort of differentiate your case from what's going on underlying, you don't have to face these problems as much. So that differentiation can make a real difference. And some of the next slide kind of oops, I missed this one here. Sorry. The next slide kind of goes to some of those comments. One is if you could show that there was no adequate opportunity to raise the ADA issues in the state court proceedings because maybe they're different, or there wasn't a proceeding, you can argue that these abstention or Rooker-Feldman bars shouldn't apply in your ADA case. There's also some argument that you can seek to stay the underlying case before the TPR proceeding is issued, because once it's issued, it's going to be difficult to obtain relief under the ADA. And then there's also the argument that you first should try to raise as an affirmative defense or a counterclaim in the lower court proceeding. And if that isn't deemed proper, then that gives you the right, well, if they say it's not proper to bring an ADA claim here, then where can you bring your ADA claim? And so you've got a path to go to federal court if you get a ruling below that it wasn't proper. Again, once you do that, though, you do have some potential issues of a collateral estoppel or the rule fulfillment. So these are tricky issues, but I think what Diane says is if you can show that it's different or there's not a sort of a parallel proceeding, you've got a much better situation. And so I would say that if you're involved in a situation where your client has been denied a reasonable modification, or whatever the scenario is, the sooner the better into court before something else is going on in court, I think would allow you to be more successful in federal court. A few other strategies. Under Title II of the ADA, one of the big defenses that state and local governments can raise is called the fundamental alteration defense. And what they're saying is the reasonable modification you've asked for would fundamentally alter how we do our services, and that the court should not be able to micromanage state and local government services. And if what you're asking for rises to the level of a fundamental alteration, you shouldn't have to make that change. And so one of the strategies is to anticipate that fundamental alteration defense and try to characterize the services as modified services that they already provide within the child welfare system. So don't say this is a new cutting edge service that they got to have. Instead you say, well, you're already providing this to people. We just want you to modify this policy or modify this practice to accommodate people with disabilities. That's a much better way to say it, because if they can show that it's something different, especially something that's different and expensive, it's going to be much harder in the courts. And then this gets to the point that the woman raised before about services elsewhere. And one of the things to look at is if you're getting some sort of pushback from the child welfare system that we can't provide this is something outside what we do, or it's too expensive, or whatever that might be. Instead, what you should do is look at, is there some sort of assistance your client could get outside the child welfare system, but that's already provided by the state? So we're talking a lot about mental illness today. So what you'd want to do is, does the department or the division of mental health already provide some services that would be helpful for your client, that your client may be eligible for? Don't just rely upon the child welfare system to get your services for your client. So a good example is, let's say your client has a hard time taking their meds, and as a result, that's affecting their parenting skills. Well, perhaps there's ways under the Division of Mental Health Services to get some medication management that you might not be able to get under the child welfare system. And it helps your child welfare case, but it's coming from another place. Okay, so that's something to remember. There's a case that just came down at the end of October, so very timely. Anybody know Paul Malika, great civil rights lawyer? He gets credit for this one. He was appointed for the lower court, and he was outraged, and he did pro bono the Seventh Circuit appeal. And it's not a parental rights case, but it's important because it talks about what accommodations courts have to make, and it does touch on this collateral estoppel rule. So I just wanted to point it out because it's a case I think can be very helpful. And it's a case by Judge Posner in favor of the ADA and people with disabilities. So I think it's a good one to note. This was a case involving a woman. She had what's called tardive dyskinesia. I don't know if people are familiar with that, but it's behaviors and neurological issues that can come from after taking a lot of mental health medication, and it has all kinds of different manifestations. You see people with their tongue goes in and out a lot. They have a hard time speaking, concentration issues, that kind of thing. And she had that, and she was bringing a case. It was a personal injury case, and she was pro se. And she had asked for a number of accommodations, and the court had given her a couple, but they denied her several accommodations. One was she wanted to have a microphone because her voice was really low. They wouldn't give her that. She wanted to have an interpreter who could understand her and then voice for her. And then she also wanted a special jury instruction so the jury understood that her behaviors were not her being sort of, odd or rude, but were something that was a manifestation of the disability. And the judge refused that as well. And the judge here sounded like just a real jerk, because one of the things that with tardive dyskinesia is sometimes it takes you a while to get the words out. And he'd be like, come on, you're wasting my time, and things like that. And it's been 10 seconds, and you're not talking. So some pretty horrible actions by the judge, which I think actually helps her in this case. because it makes her more compelling. So she lost her trial court case, and she filed in federal court, arguing that the court itself had violated the ADA by denying her the requested accommodations. And as you can imagine, the state here argued, wait, we've already litigated this. This is an issue preclusion. They denied the judge already denied these accommodations. There's collateral estoppel. You can't raise this in the federal court. And what Judge Posner said is, well, you can't, typically, you're right, this is issue preclusion. This is collateral estoppel. You shouldn't be able to raise this issue in federal court if it's been litigated below. However, there is an exception to collateral estoppel, and that is a fairness exception. And he said she did not get a fair day in court. This was unfair what this judge did, and therefore the judge was wrong here. She should get accommodated. There was a violation of the ADA, even though that had been ruled upon below. And so you got this sort of Judge Posner going out on a limb, frankly, on an issue that typically I think most folks would lose because of the inherent unfairness that the person had faced at the trial court. There is a strong dissent, and so since it's relatively new case, I guess there's a possibility that there might be a petition for a rehearing en banc, or of course they could also ask the Supreme Court to review this. But it's a 2-1 decision. It's very compelling language, and hopefully will not get reversed and will be something that we can all use in the future. Yeah.
Just a point on that. Who represents the state on this? The Attorney General or someone from the courts?
The Attorney General. Yeah. And Paul Monahan was telling me that Judge Posner was really hard on the Attorney General during oral argument. He said, sometimes you leave oral argument from a Seventh Circuit opinion, or a Seventh Circuit case, having no idea which way the courts are going to go. He's like, I was pretty sure I was going to win because what Judge Posner was doing was not really taking issue with the Attorney General, but taking issue with the actions of the judge here, who the Attorney General was representing. Did you have another question?
This was originally a damages action of some sort?
Yeah, the question is, was this originally a damages action? It was some sort of personal injury case, and she was pro se and asking for accommodations that she didn't receive during that case.
Was the judge involved in this matter? Was he somehow openly sympathetic to the defendant, or was he just a jerk who doesn't understand disabled people?
So the question is, was the judge sympathetic to the defendant or just sort of a jerk? And I don't know. I mean, it sounded like a jerk to me, but there may have been some bias here or some sort of other reasons why. But again, all I know is what I read in the opinion, but at least the way it was painted, the judge seemed incredibly impatient and incredibly unsympathetic to somebody who was doing the best they can in a really hard situation. So again, we talk about bad facts making bad law. This is, I think, some good facts, good in quotation marks, that make some good law because it was so extreme. So the last thing I wanted to talk about in the final 2 minutes is some new technical assistance guidance that's come out from the Department of Justice and the Health and Human Services Office of Civil Rights. And this is a handout that's back there that you should have picked up. It's the one that looks, you see like the eagle and then the seal of the Department of Justice. This guidance is great, and I would really encourage you, if you have a case involving a client with a disability, to really check it out, because it goes into a lot of detail. Obviously, we're not going to cover it, but I just wanted to kind of go over some highlights from the guidance that might be useful. And again, it's guidance, it's not regulations, so sort of what its authority is in court, I think, maybe not as high as if it was a regulation, but let me just give you some highlights. One is it confirms that Title II and 504 applies to all child welfare activities, services, and programs. So the ADA specifically does not mention child welfare. It gives other examples, but it's not there. So the fact that we now have guidance saying, yes, the ADA applies to this is helpful. It also says that the ADA and 504 apply to activities, services, programs of family courts. Again, we don't have that anywhere else, so that's a great thing to have. It also says, and I think this is important as we see the privatization of services, is that Section 504 and Title II apply to private contractors of child welfare agencies and courts. So as we know, there's a lot of privatization and contracting out of some of the services of the child welfare system. So your claim would not be against the private contractor under Title II. It would still be against the state, still be against DCFS, because they have a responsibility even if they contract privately. Now, you might have a separate claim under Title III, which covers private entities, against the private contractor, but you definitely have a primary claim under Title II against the child welfare system, even if it's contracted out to a private contractor. Then they reiterate that child welfare agencies and courts must make reasonable modifications to the policies, practices, and procedures to accommodate people with disabilities unless there would be a fundamental alteration. So again, that's what they're doing here is they're reaffirming the general principle, but applying it specifically to child welfare agencies and the courts. They also talk about that child welfare agencies and the courts have to provide auxiliary aids and services unless there would be an undue burden. So examples of that would be, like we talked about before, the American Sign Language interpreter for a client who's deaf, alternate formats for somebody who's blind, accessible location for somebody who's in a wheelchair. They confirm that no surcharge can be applied or imposed for using those services and aids. And also they affirm sort of a common concept for people who are deaf that you shouldn't use family members for interpreting, especially in the family law, parental rights context. That's incredibly inappropriate. They talk about how service plans for parents must address individuals' disability-related needs, and they talk about sort of what we talked about before, and the question that the woman asked before is that sometimes you need to get services outside the child welfare system, and that's an affirmative obligation that the child welfare system has under the ADA to accommodate the person. Child welfare system can't say, well, we don't do that, so we're not going to provide it, but instead they have to work with you to explore what other services are out there that might be available, like the Division of Mental Health Services. They confirm that there is a direct threat of defense. So if there's a client who is a substantial risk, a significant risk of substantial harm, that harm can't be reduced by reasonable accommodation or modification, that they can be denied services or denied certain access to certain programs. But they say that you can't say somebody's a direct threat just because, oh, that person has schizophrenia, they're threatening. That sort of knee-jerk, stereotypical approach. You have to do what's called an individualized assessment that's based on current objective medical and psychological information. So that's important. That's a reaffirming, again, of the general principle and applying it to parental rights issues. It also, and this is another strategy to have when you have maybe some challenges on bringing this up in court, is that you can, again, they say that you can raise a Title II or Section 504 claim in child welfare proceedings, or you can file separately in federal court. And they don't address the adverse precedent in their guidance, of course, but they do. This is something that people can point to and say, well, the federal government interprets the ADA to apply here. And maybe that would be a basis for overturning some bad precedent that's out there. They also indicate that in addition to going to court, you have a right to file with either HHS or Department of Justice. And I've given you links to how you can file online any complaints. With respect to filing complaints, I had two things I wanted to mention that can be traps for the unwary. One is that generally you need to file your complaint with the DOJ or with HHS within 180 days. Now, there is a good cause exception that they can apply, and there's also what's called a continuing violation, where you can say, well, they're continuing to deny this, therefore the 180 days hasn't run. But generally, if you want to raise something in these complaints, the best strategy is to make sure you file your complaint with DOJ or HHS within 180 days, and then you don't have to get into that good cause issue. Diane?
Are DOJ and HHS synonymous here, or is there an advantage to filing with one or the other?
You know, what the question is about is DOJ and HHS synonymous, or is there an advantage one or the other? What happens is HHS does an investigation, and then they will look at it and try to work it out, and then they would, their only sort of hammer is to threaten to take away federal funding, which they never do. And so what happens is if they can't get a resolution, they then refer it to DOJ, and then DOJ will file. What happens with DOJ, if you file with them, is they would do maybe a less in-depth investigation. They may refer to HHS, but they would be more likely to go to litigation than HHS. HHS does their internal investigation, tries to work it out, and then ultimately they refer to DOJ. So I think, you know, if you want a sort of more in-depth investigation without litigation, HHS is where I would start. But if you feel like they're not moving, you can quickly say, please refer to DOJ, and then they would look for litigation. Now, they don't necessarily take it to litigation. Obviously, they have limited resources. But DOJ is more the litigation, investigation side, because they can bring litigation affirmatively, even if you don't bring it yourself. You are, in those kind of cases, the United States is the actual plaintiff, so to speak. but they're using your claim as a basis to bring their case, especially if they can show it's a systemic issue, they're more likely to take it. The other sort of caveat I wanted to point out is that those of you who may be familiar with the EEOC and filing with the EEOC, that tolls any kind of claim in federal court. You have to exhaust your administrative remedies before you can go to court. Because you can go straight to court under Title II of the ADA, filing with DOJ or HHS does not toll your right to file in federal court. So what that means is if you file with DOJ and HHS, you still need to make sure you're watching your statute of limitations, which is 2 years from the adverse action. And if you don't file within those 2 years, even if your claim is pending with HHS or DOJ, you lose your rights in court. So you just kind of have to watch both time frames, the 180 days to file with HHS and DOJ, and the 2 years to file in federal court, and one doesn't stop the other. So I think I've got 2 minutes before the end of my time. Any final questions that anybody has? Yeah.
I wonder if you could give us some examples of modifications that we've asked for specifically for people with mental illness.
Yeah, the question was examples of modifications for people with mental illness. Well, a lot of times what people with mental illness need is change to policies and practices. They're not going to need sort of the assistive technology that I gave examples of or sign language interpreters. So maybe there's a requirement that you have to have something done within a certain time frame. And if the person with mental illness can say, I can't do it within that time frame because of my mental illness. And typically, if you're going to do one of those kinds of where you're seeking a change to a practice or a policy, then you need some sort of psychiatrist or psychologist support. And Title II entities are allowed to access that. They don't have to just believe the person. Another thing is timing. Another timing issue is, for instance, a lot of people with mental illness are pretty groggy in the morning because of medication. And so maybe they would ask for a modification of when they need to meet with their social worker. So maybe the social worker says, I only meet with people in the morning. Well, maybe they need to meet in the afternoon for their mental illness, and that would be a change in a practice. And unless they could show it would be some sort of undue burden or fundamental alteration, that would be a modification that needed to be made. Any other questions? Yeah.
Personality disorders, traditionally referred to as Axis 2, are those considered a disability?
The question is, are personality disorders considered disability? Yes, they are. And that I haven't seen any case where somebody's been found not to have a disability with a personality disorder since the ADA Amendments Act. Before that, if people could take medication and it didn't rise to a level of substantial limitation, they might have lost. But generally, those are definitely considered disabilities under the ADA. You want to take one more question? Or we,
Yeah, go.
Okay. Got 2 more I'll take, and Diane will cut me off when I need to. Go ahead.
Very similar question. Is the state of being in treatment for addiction to drugs? Say if you're on methadone treatment, is that considered a disability?
So the question is, what about people who are on methadone treatment? So the ADA talks about that if you are currently a user of illegal drugs, you are not covered by the ADA. But if you are taking prescribed medication, even considered drugs, so to speak, then you are covered by the ADA. Or if you are a passive user of drugs and you've now gone through a rehab program, you are considered a person with disability, that record of disability that I talked about. But the ones who are currently using illegal drugs without a prescription is not covered by the ADA. One last question?
Just, it's not really a question, but a comment. On my case, it really is a very narrow case where we had no choice but to request guardianship rather than termination. We had no other argument. I didn't really want to tell the court to take it, but because my client was mentally ill, I had to exhaust all the remedies. But there is a case out there where the mother was schizophrenic and she had a relationship with the child, and they sought to terminate under that section. But it was found to be not in the best interest of the child to terminate. So it doesn't foreclose you from making a best interest argument. There's also other cases. This is not really the presidential case that appears to be, because there's other cases too that already have kind of leaned against even the service aspect of it. And I was trying to find something at the termination level to change it. So I just kind of want to say, read the case very carefully, because it's a very narrow case. Even though the appellate court, I think, went overboard with their opinion, the actual opinion really is far greater than the facts and support.
Right, and so just to quickly summarize for folks on the webcast, I was just talking about the Illinois case that I talked about. We have the actual attorney who is on that case, is much narrower maybe than I presented. I think the thing that I was talking about, and maybe that is a narrow issue, is just the concept of whether the ADA applies to termination of criminal rights. But the general analysis of, that you're talking about that you usually go through for parental rights cases, it isn't changed by this case. But I think that ADA issue for termination of parental rights, it is bad on that narrow issue. Yeah. All right. Thanks very much for your attention.
Thank you, Barry. Once again, an outstanding presentation. Please fill out your evaluations, as for people online as well. Please fill those out. Our next presenter, we've gotten a note that she's running a little late, but we will reconvene at 2:05. Hopefully she'll be here. And we will come back and have a presentation from a non-lawyer about working with people who have mental health issues. Claims and other issues, and we can moderate the panel. So what I would do is start by talking about one of my cases, and then if our panelist still isn't here, then Susan might add experience of hers, and then we can start our discussion and proceed with our panel.
Yeah, everybody, please, in your materials, there is a single page with 3 questions on it. Just take a look at those and see what you have on, any notions you have about those.
So during our last session with Barry Taylor, he talked about ways in which the ADA and Rehab Act claims can be brought in the context of parental rights and child welfare matters. We at the Family Defense Center filed such a case in 2013. It's a really fascinating case, and it has the potential to change some policies and practices of the Department of Children and Family Services. So I would like to just describe the case and then call your attention to the opinion, the federal court opinion that's ended up sustaining the disability claims after first dismissing them, and then we did briefing on, and we got the claims reinstated. It shows some of the trickiness of pleading in this area, and certainly we were not as sufficiently aware of some of the nuances of what we needed to plead. So just to describe the case, our client, her name is Bridget. She is a teacher, a substitute teacher, and has a social work background as well. But after she had her baby, whose name is L.W., using her initials, after she had the baby, she had some depression and had some difficulties keeping employment, and while she was a single mom. She moved in with her parents, with whom she has a very stormy relationship, but that was, what her available housing was, and so she lived with them. At some point, and we don't exactly know why, at least I don't, the parents made allegations against her, their daughter, based on some somewhat strange behavior of hers that they alleged. And they said to DCFS that she was a paranoid schizophrenic who did not take her medicine. So in response to this allegation to the hotline, DCFS came out and effectively took protective custody. We have some disputes of fact, but basically they took protective custody and told her, Bridget, to go get an inpatient psychiatric evaluation in order to get her child back. So Bridget tried to do that, and nobody would admit her because she did not have paranoid schizophrenia, and she did not meet the criteria for inpatient hospitalization. Subsequently, there was a safety plan that was issued against requiring Bridget to remain in the home of her parents and to have no unsupervised contact with her child. This went on for 8 months. The case went to a private agency with the safety plan intact. She was indicated for allegation 60, which was environment injurious, and that eventually she got cleared of. There was never any juvenile court activity. So this is purely a DCFS, a case against DCFS without the problems of the court, Rooker-Feldman doctrine and all the other kinds of concerns about abstention. So we sued under the Fourth Amendment, the 14th Amendment, the ADA, and the Rehab Act, and we also had claims about her impairment of her liberty interest in employment because of the indicated finding against her being issued under allegation 60 without consideration of exculpatory evidence. So the ADA claims ended up getting dismissed, and it's a really kind of torturous discussion in this opinion at paragraph 7 at the bottom. So the judge there describes why he first dismissed the complaint. He says he concluded that she had not satisfied the causation requirement because our complaint alleged that defendants had decided to indicate Bridget and remove LW from her custody, not just because they thought she was suffering from schizophrenia, but because of reports that she was acting bizarrely and was posing a threat to her child's safety. Well, in response to that, we thought, well, we're saying the same thing. We're saying you're taking a mental health diagnosis and using that to conclude there's risk rather than having a genuine safety concern. The judge hadn't read it that way, so in response, we said we have shown that the discrimination was because of the perceived disability, and he then reread the complaint and decided on the next page of that opinion that, well, we could have, this wasn't the obvious reading of what we had said, but at the bottom he says there, the inference that plaintiffs now urge the court to draw from these statements that defendants simply assumed Bridget's purported disability was endangering her child's welfare is perhaps not the most direct interpretation. In other words, we hadn't pled it so clearly, but in light of other statements in the complaints, it's at least plausible. So he reinstated the complaint because he concluded that we had adequately pled the claim that the action was because of the disability and not because of the risk, actual risk. So a little bit of hair splitting, and I think it shows some of the challenges as well as the potential for making claims in this area of law. Where we are in the case right now is we are about to present positions for policy change, including change to the access to mental health records policy that we talked about this morning. We are at the table in settlement discussions right now. The case has been sustained in terms of over the motion to dismiss. So, and the claims about the seizure of the child and the threatened and coerced safety plans and the misuse of the indicated reports, all of those have been sustained. So we are going forward with our federal suit on behalf of Bridget. So anyway.
I love hearing when something is working. My name is Ken Dean. I'm a private attorney here in Cook County. I do a lot of juvenile protection related work, do some criminal as well. I think we all know who Diane is. Ms. O'Neill, could you introduce yourself briefly?
Hi, I'm Susan O'Neill. I'm from Peoria County.
You've been a public defender for a number of years.
I have worked in every capacity other than the black robe for 25 years in juvenile court.
There we go.
And I represent disabled people for equally as long in other capacities, different types of cases.
Thank you. So I asked you all to take a look at the sheet I handed out. So, the first question, you have a client with a live juvenile court case who does not communicate effectively, hostile, uncooperative, and paranoid. Mental health is not an identified issue. You're seeing one now. It's gotten to the point where you can't really, you don't know if you can represent this person. Now, before this morning's lecture, I suppose some of us would struggle a lot to answer this question, but I'm going to put it to the audience. Does anyone have an idea as to how you respond when you're faced with that situation? Because I think it's a rather common one. Let's see if I get one from the audience first. Anyone? Any thoughts?
Withdraw.
Withdraw is one answer. Yes, withdraw. And sometimes that is absolutely necessary. Just my 2 cents on that. If you're in a system where they have, where there are a number of appointed counsel available, what often happens, I know it happens here in Cook County, bar attorney or public defender withdraws, they turn around, the court turns around and appoints a different bar attorney. It's worth a shot. I don't know what else you can do at that point sometimes, but sometimes merely different personnel can make a difference. You never know. Ms. O'Neill.
No, I do think if you're court appointed that because I had to file one of these motions to withdraw and ended up withdrawing my motion to withdraw because in part there was no one else that was going to be able to do a better job, and that was kind of where the court was leaning, and I saw which way the wind was blowing, and I acknowledged that there was no one else that was going to do better. It's a very difficult client, and all I would be doing was passing this client on to someone else who's probably less equipped to deal with this person's idiosyncrasies and difficulties in communicating and reasoning. But, I think that, however, sometimes when one of my colleagues has bailed and I've gotten the case, because you're absolutely right, sometimes they do just point another assistant public defender when there's a conflict of personalities. That I have a case now where the other lawyer was actually afraid of the client. He was a male colleague, was afraid of the male client, thought he was hostile, thought he was threatening. This gave me a little bit of trepidation about meeting with him in my office, but I don't know, maybe it's because I've represented disabled people for a long time. He and I get along just fine. He's never been threatening at all. So sometimes a difference in personnel may be a better solution.
There's so many things in this area that are not in the law, that are not established. I mean, there are times when you're dealing with mentally ill people, you're going to have to wing it a little bit. And that's just the nature of it.
One client, she wasn't hostile, but she's been in the system for a long time, and I've determined that she's educated. She graduated from high school. She was never in special ed, but she clearly is having a real disconnect in using good judgment and keeps making repeated, like almost bizarre choices. And she's been in counseling and so forth. And I discussed it with her first, but I asked if I could file a motion and have a psychological evaluation where there had been none. Because I went to the client first and said, I just want to explore every possibility to make sure that we're not missing something, that there's not an underlying mental illness that's somehow interfering with your ability to accept or process, the information that you're getting in counseling. And in the end, she embraced it, the caseworker, the judge, everyone embraced the idea as a good idea. But I did go to her first, and I was polite about it and told her why, and she said, sure, because she wants to get her child back, and if I put it to her that way, instead of a judgmental way, she was not against that motion at all.
Up until that point, she's repeatedly making bad decisions, and it's inexplicable to you.
Right. I'm like somebody said earlier, I'm not a mental health clinician. I think Marc said that, but I did have no other explanation, and I think I needed to leave no stone unturned because the time is ticking.
I had a very similar situation as well, where I had a young man in juvenile court whose child had been taken away due to some inexplicable injuries. I don't believe he ever did it, but that's beside the point. And he was just struggling to make meetings, struggling to make it to appointments, struggling to make it even to visits. And one thing I I carry around is I spent a few years doing assessments on people before I was an attorney. And it was obvious. It was, 5 symptoms right in front of me. He was depressed, clinically depressed, 311. He could not function. But nobody had caught that. Everybody's looking at this guy thinking he's just a mope. He's just dumb. He's not smart. He's not bright. That's why he doesn't say much. That's why he just kind of hangdog look all the time. No, he was actually a fairly bright young man. He got through it, but it was visible. It's obvious. So he was not getting appropriate treatment. I did it myself. I sat up in front of the judge, in front of everybody, after I had a long conversation with him and talked to the worker, tried to get the worker to do something about it. Finally went up in front of the judge and said, this man needs an assessment. He is depressed. This is why he can't get it done. Y'all are talking about 9 months are coming up here. No one's ever provided him treatment because nobody has recognized he has a problem. And lo and behold, the judge asked my client a couple of questions from the bench and ordered the agency right then and there, get this guy in counseling. You've been wasting everybody's time here. It was worth it. It was a disclosure. I wasn't happy about doing it, but I felt that I had nothing else.
How did you talk to your client about that before you brought it to the judge?
I had a very good relationship with this young man. He did, listen to me, and he knew I was trying to do what I could under, it was kind of a tough case anyway. How I approached it was, I asked him, why are you, I know you're not doing something during these times. I know you want to see your child. And he just kind of, he started talking about how he feels. I'm like, oh, there it is. It's obvious. It's like 5 symptoms, boom, 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 just like that. Yes.
Is this something you would recommend doing before adjudication or after? Like if you start to suspect something, but you're still pre-adjudication.
If your client is so impaired as to make it impossible for you to put up a defense for an adjudication, that's a whole different question, especially in juvenile court where, I can remember a client I had in the public defender in a criminal context was hostile to me, was denying, would not take a plea. I BCX'd him, a behavioral exam, just to cover my bases. But that's a criminal context. Here, you raise your hand and say, hey, by the way, in addition to all the other concerns you people have, my client's also nuts. That's tricky, pre-adjudication. The case I described, my example, it was well after adjudication. It was never anything we adjudicated. We skipped it because it was just, well, it was largely skipped. There wasn't a whole lot to adjudicate there. But time marched on and he wasn't getting any better and things weren't getting better and had to do something. Diane, I know Diane has a recent case with a difficult client, which I find your agency's response interesting.
Which one are we talking about? Trying to remember this one. Oh, yes, okay. Yes.
Yeah, when it comes to the point where the client is threatening towards their counsel.
Yeah, well, okay, so we had a client and she had a hearing coming up. We set up multiple appointments for her to come in and help us prepare for the hearing, go over her own testimony and her potential witness testimony and deal with the likelihood of cross-examination by the opposing attorney for DCFS, because they do routinely in expungement hearings call our clients as their own witnesses. The case itself involved allegations against her for causing, I think it was a substantial risk environment injurious case. And this was a case involving some mental health allegations against her, but we thought she was pretty high functioning. She did have employment at the time. There was a lot of alienation going on between her children and herself. But at the point that we were preparing the hearing, we were having increasing difficulties in communicating with her and getting her to prepare for the hearing, and she kept asking, well, can we postpone this? And finally it got to the point where we were setting up appointments. She was missing them, and we had only a few days before the hearing So after she missed one of these appointments, we decided we had to withdraw. Lo and behold, a year later, she has threatened to sue us for our failure to refund funds because she was a client that we represented on a sliding scale basis. So we had to really document our decisions and our appointments with her and make sure that we have grounds for our withdrawal. We were certainly allowed to withdraw. But now she is rewriting history in terms of, claiming that she had insisted that we get her an extension when we in fact had never really agreed to that and so forth. So I think a lot of times when we're in these situations with clients who have some form of a mental illness, we have to be even more on our toes to document our own decision making and our communication with the client.
Yeah, I would second that. I'm afraid to say, and I hate to promote the notion of ever having an adversarial relationship with your client, but it's a protection for you, and to some degree it may protect the client as well if you're documenting what you're seeing and what your concerns are if such a situation arises. Let's move on to question B then, unless anyone's got any other things, because any ideas are valid. This stuff is not all in stone. You have a client in a live juvenile case who's been getting counseling on his or her own prior to DCFS involvement. You secure the notes from this provider through informal channels, such as the client went out and just asked for a copy. These notes turn out to be terrible, thin, not helpful. The provider is clearly not addressing anything of substance. Part of your defense has been that the client is already engaged in therapy. And this counseling, evidence of this counseling, would be of any use in the court case.
Absolutely.
In what sense?
You can always go in and say, when they say, well, she's got problem A, B, and C, you can say, she's already seen a counselor and tried to deal with problem A, B, and C.
Mm-hmm.
And a lot of times that'll be enough to carry the day.
Okay, anyone else?
I think it's for
I think the answer was, I'm sorry, the answer from the audience was that yes, your response is yes, she's already addressing A, B, and C through this counseling. And go ahead and use it.
I mean, the quality of the counseling, let the other side raise that. There'll always be that point of view, even if the quality, at least my experience has been, even if the quality of the provider is, of some substance, the other side, or DCFS caseworker, as a matter of fact, might say, oh, well, that's not good enough because you're not doing our type of counseling. However,
they're not DCFS contracted, therefore we don't necessarily take what they have into consideration.
Exactly.
Anyone ever heard that one?
Yes.
Yes. Yeah. So, and
Tyranny of the experts, anyone?
Yeah. Especially at disco or permanency, the fact that the parent is taking the initiative of their own to seek out help and get their own services is extremely impactful. Just that fact is very impactful. And I mean, if the notes are terrible, you can always talk to the provider and call them in to testify if you think they will be better off.
I guess one question I have always is what is the purpose of the counseling requirement and what is it meant to address? Because what often it's just a proxy for, is this person cooperative generally? I mean, there may not be any real connection between the issue of injury to the child or care of the child and what they're supposed to get counseling for. But so this becomes a cooperation hurdle. So what the client is doing is actually showing cooperation, and it really doesn't matter what the underlying issue of that the counseling is for might be.
Diane points out a screaming irony is how often do we get a person who's been referred by the agency, and the reports from the agency, the DCFS approved, are thin, don't really tell us much, but that's okay. And that's something else? Yes, anything else you want to throw in there?
Well, all I was going to say is that oftentimes DCFS or their designee, the private contractor, is asking for counseling, but they are not specifying what they want the parent to work on. what issues. And they are taking, in our area anyway, a very long time to make the referral to counseling, even after the agency's been court ordered to make the referral. And I talked to the DCFS regional attorney about that and about the money, follow the money kind of thing. And she said that that the agency is given a big chunk of money for a family, and that's why they try to keep the services within their agency, because then they don't have to pay for the services at a different agency. So if they have a counselor there, even if there's a 3-month waiting list, they want to put your client on the waiting list, which you're going to have a permanency review in another 3 months. So then they would have barely gotten to see this counselor. So your client goes out and finds somebody else. And I think that it does show cooperation, but in our circuit, that if you want that to count, they want DCFS to at least give their usual referral packet, because they feel as though the parent isn't always, whether it's true or not true, isn't always disclosing all of the real issues. And that if you want it to count, I think you need to find qualifications of the counselor versus the one versus the other, and also make sure that any information the DCFS would have given to their private agency counselor, that this counselor has the same information, so they can't use that against your client, that, well, they didn't know everything, they just listened to what your client had to say, and they probably didn't tell them everything.
So since we've started on the panel, even though our presenter has arrived, we thought we would do panel for another 10 minutes and then have the presentation, and then we'll resume with more discussion after that. So Steve, do you want to come on up? Sure. Steve was from LAF, does a lot of juvenile court representation, including some interesting disability cases.
Yeah, I've been seeing Steve work for years. He's good at this, he knows what he's doing, and well regarded. Finally, I think question C was very clearly addressed by one of the earlier speakers, so we're going to move on from that one, I think. We got a good answer on that one. Is a little less squishy than some others. I'm sorry, you had a question about our last topic.
Oh, I was going to mention, I have a number of cases where the state is alleging anticipatory neglect based on prior mental health diagnoses. And if I had a client who was in counseling prior to DCFS involvement, I would also use it to combat that by mentioning that this is, however, whatever you're dealing with in counseling, this is another set of eyes on this person. And it is a mental health professional who they are seeing weekly to kind of combat the idea of an anticipatory neglect.
And let's face it too, if the person who's been seeing your client before the DCFS involvement, if they had serious concerns about any children in their care safety, they would have already hotlined it, which is a great thing to point that out on the stand. You know. Yes, all the way in the back.
I wanted to say one thing about Steve. It's
Yes.
happened to me in a couple cases where I've represented mothers and DCFS investigation, and they're doing the safety checklist, and they ask the parent, have you ever been depressed before? And this time, when I'm preparing my client for the interview, there's a lot of postpartum depression. And I was prescribed medicine by my doctor. Most of the time, they're asking for guidance as, well, should I bring that up? You know, are they going to make a big deal out of it? And of course, once they tell you, you can't tell them, don't tell them that. But I think your response about, well, it was handled. You know, it's a normal thing. People get postpartum depression, but that seems to come up quite a bit with my clients.
My general practice has been is my practice. I can only speak to myself here. Is if a client has a treatment in place, and I know it's going to be a positive report, I say go right ahead and give it to them. If the client has treatment in place, well, virtually every client I've had has already got some sort of treatment in place. It is going to be positive.
Right.
So certainly nothing I've encountered in the past. I don't think you necessarily always push the investigative department to articulate what is the risk. what is the harm? What is the neglect? Well, your client has a diagnosis. No. That's not a risk. That's a risk factor, but it is not in and of itself a basis for anything. And try to keep them focused back on that. Diane, you had something you wanted to add?
No, okay. Steve.
Yes.
Oftentimes, the agency will I guess, disqualify a counselor because they haven't got their referral packet, meaning they haven't got their narrative as to what transpired in terms of abuse and neglect. What do you recommend that your client bring a copy of whatever the indicator report or a petition to this counselor that they're going to, so that they can bolster that counselor's credibility in the eyes of the agency? Or
okay, the question was the agency says, okay, your client's seeing a private counselor, but this private counselor doesn't have, say, the RIA, the investigative packet that brought the matter to the court's attention, for example, does not have our psychologist's evaluation of your client. Therefore, I'm paraphrasing, therefore, your client's privately retained counselor, really, whatever they have to say doesn't mean much to us because they don't have all this collateral. Is that
right?
Fair characterization?
They're operating in a vacuum.
Right. In other words, your client's counselor is not operating on our facts.
Right. Yep. I had a case where there was almost a 3-year standoff over this, and it was all pre-trial. I mean, we were taking the strong position that the therapist should not be effectively tainted by all the information, and that, in fact, the therapists are to do therapy. They need to work with the client on the client's issues and not on whatever the assumption is of the truth of the allegations. I mean, I think it's very problematic if it's pre-trial. If it's post-trial, it still is problematic in terms of versions of facts that may be subject to appeal. I don't completely know how to resist it. Sometimes it may be beneficial, in fact, for the therapist to at least know what's being alleged, because the client certainly knows that and has to address it. But I'd be interested in other people's thoughts, because it is a challenge in navigating these demands.
Let me follow up with that, Diane. So if you're able to successfully insulate, for lack of a better term, your client's therapist from the various allegations, that would seem to me to dilute that therapist's potential usefulness if you get to a return home situation. And so,
in the case that we had, there were possible criminal charges at the same time, so it was, there was a desire to keep the therapy as clean and pure as it could be. Now, I don't know if there had been criminal court in fact, there wasn't, if that would have worked, but.
I currently have a case where the competing versions of reality is pretty much the central problem in the case. At least from the therapists, there have been more than one in this case, they're trained to, as Diane suggested here, to take the client on their own terms. It's thankfully they were good therapists and they wanted to be advocates for the client, but and so I felt that our job was to highlight the disconnect, the factual disconnect, and ask them to explain it in clinical terms. For various reasons, we've never gotten to that point in this case. But it's essentially a variation on the what I perceive as in my amateur psychology as the need for the judge and various other actors in the courtroom to hear the client fall down on their knees and say, I admit it, I admit it. Have mercy on me, and then that clears the moral air, so to speak, and maybe progress can be made. But on the other hand, anyway, but of course they would, if you ask them that, they would deny it. But it's a central problem, I think, and the best you can do with clinicians is to illustrate the tension that it causes in the client because of what you're telling the client in terms of, well, the judge has made these findings of fact. That is true. Now, admittedly, judges make all kinds of errors, but this is the truth for this case. So that's, I think, the best you can do.
The idea that clients need to admit in order to make progress in therapy is something that gets pushed a lot in juvenile court. It has not necessarily stood up on appeal. In the Johann K. case, the public guardian argued that the client's failure to admit to abuse, which the appellate court ultimately found was not present, but the demand that they admit to abuse could not be sustained, and you could not draw the conclusion that the person failed to make progress in therapy because they failed to admit. They can discuss the issues, and certainly therapy should be discussing, what the parent does acknowledge or doesn't acknowledge, but the demand that they acknowledge abuse isn't sustainable. So I think that's part of what Steve's talking about in terms of, accepting the reality and the mea culpas that go with that. And I don't know, it seems to be part of just the demand for the juvenile court to always be right and for the state to always be right.
Well, I apply the amateur psychology the other side. It's called authoritarian personality disorder. I suggest we look it up. It's a very prevalent and increasingly common disorder in the United States of America. We'll see how it plays out in the next year. With that, I think we're at a good point to take a break and let Kasia, I'm sorry, I'm not going to try your last name. Kasia do her presentation. Thank you for your patience and letting us taking things out of order. Let's give her a couple minutes to get set up. So we'll take 5. Thank you. We'll resume after Kasia's presentation.
Yeah, Susan will introduce her.
No,
Kasia. Oh,
give her a minute to set up.
Okay. Were you going to introduce her? Yeah. Okay. Susan, I want to rest in real quick. Okay.
You know. Yeah.
I do.
That was a good way to. Yeah, well, it was a good way to.
Hello.
Susan was going to introduce you, Kasia.
Oh, great. I'm just going to set up a little bit here so I can put these slides up.
Yeah.
In radio. Y-O.
Someday I'll have, but he's put on the record.
No, I was going to come.
Like if he was closing up his kids reached out. And so they can every business. We got in our site. Right on work, and I would have to thank them knowledge on the record. We do that as a right. No. speaker, Kasia, and I'm not even going to remember her last name because I'm sure it would be not good. Anyway, Kasia and I have known each other for some time. We worked together as board members at NAMI Metro Suburban in Oak Park. And when Diane was looking for someone, a non-attorney, to speak for this segment, I thought of Kasia right away. She is a very dynamic young woman. She's dedicated her entire adult life to the mental health field. She works as a counselor, as a teacher, the former president of the Chicago Counselors Association, and she just came to us from presenting at the Illinois Counselors Association conference. So that's why she was running late. But she's going to help us today to better serve our clients with mental illness.
Thank you. Hello, everyone. My name is Kasia Wereszczynska. I was born in Poland, and so that's kind of a little bit about my background. Besides being passionate about mental health, I'm also very passionate about multiculturalism. And I think that for both of us, you that work in the law area, and then for me in the mental health field, is also really important to understand culture so that we can provide effective support for the people that we work with. So the first part of the presentation is on trauma-informed work, and this is working with individuals with mental health disabilities. There is going to be some room for questions so that you can maybe there's something that doesn't really make sense to you, or maybe it's something that you don't need, but I want to make sure that I answer everybody's questions as much as I can in this room. So a little bit about my history. I am a licensed clinical professional counselor, and I'm also a yoga instructor. I'm certified. I spent 1 month in Florida studying 200 hours of yoga so that I can use meditation and mindfulness when I work with my patients in crisis situations. So in inpatient treatment facilities, I work with individuals who present with suicidal and or homicidal thoughts and maybe have psychotic episodes and breakdowns. So over the past 7 years, I worked with St. Bernard's Hospital in the emergency room as a crisis therapist, 11 p.m. to 7 a.m. shift for 2 years full time. Simultaneously, I worked with ADA-S Community, which is a nonprofit organization that is a counseling agency, and I'm sure that you probably are familiar with this because we have the same clients that we work with. And so in that position, I was a SAS crisis worker, which stands for Screening Assessments for Psychiatric Psychological Disorders, more specifically with children, adolescents, and young adults, anybody under the age of 21. So this is a screener position where we're a third party to be able to go to different emergency rooms, go to people's homes in the communities, work with different shelters, for example, Aunt Martha's shelter. Sometimes we would go to the police stations to do evaluations, more specifically with cases of human trafficking and working with runaway teens. And then in outpatient settings, I am currently helping run an IOP program at Chicago Behavioral Hospital, where I work with individuals who have some trauma, some addiction, anxiety, self-esteem issues, and stress management issues. So that's a little bit about my background. I've worked with hospitals, including Holy Cross Hospital, Jackson Park Hospital, Chicago Behavioral Hospital, Chicago Children's Hospital, St. Elizabeth Hospital, Highland Park Hospital. So I've been kind of a little bit all over the place responding to different crisis emergencies. So I have 7 years of experience as a crisis worker. And before I was a crisis worker, I worked with TASC, which was affiliated with the mental health court at the Cook County Jail. And I worked very closely with Judge Fox, if any of you are familiar with Judge Fox. So today's learning objective is by the end of this presentation, our participants will have a better understanding of trauma-based therapy and its relationship to working with children in foster care and adults with disabilities. More specifically, maybe working with the parents that you work with or the guardians that work with the children that they have. The audience members will also have a better understanding of the definitions, like how trauma impacts the population, methods of psychotherapy and counseling, and the means of measuring treatment outcomes and the goals. I know when I spoke to Susan, she was really interested in having me talk about what kind of counseling do you want the judge to specify for these individuals to get the specific kind of counseling that they need in order to fulfill whatever the court orders. So who can tell me what is a definition of disability from your experience? I'm assuming most of you work with some type of mental health disability or physical disability as well. Yes.
Well, we have both, but today's lesson is about people with mental health issues. That's the disability we're working with today. That from the parent's perspective, not the child's perspective, but the parent who has a mental health issue, how do we help represent them? What is our strategy? What should we be asking for? What should we be looking for?
Okay. So who knows from their personal experience or professional experience what is a disability? How do you know that these individuals have a disability? Is it just their diagnosis? Yes.
Well, I assume most of us are lawyers, and if that's all the training we have, and that's true in my case, I think of it in terms of how the Americans with Disabilities Act defines disability.
Okay.
So I think of it in legalistic terms.
Okay. Anybody else? Yes.
Well, I guess for me, it's a combination of the diagnosis and the functionality. They may be diagnosed with something, but they function perfectly well, or vice versa. They may not be diagnosed with something, but don't function very well. So to me, it's a combination.
So from the work that I do, most individuals that present with a mental health disability, they're actually unable to work. They're unable to keep a job, and they cannot function in one of the three areas, which means occupational. Maybe it's in their personal lives, like being a parent, right? A fit parent. Difficulty maintaining healthy relationships. So I'm sure we'll talk a little bit about effective communication with those kinds of individuals so that you don't get frustrated, so that you can better understand why they are the way that they are. And then obviously foster care. I'm assuming that you specifically work with children in foster care, correct? So you already know what that is. And then trauma too it's a perception, correct? So in your area, I'm assuming that these children are either sexually abused or physically abused, correct? Is that?
In some cases, just neglect.
Or neglect. So neglect cases, okay. And then there's trauma-based therapy, which is more specific to working with individuals who have some kind of a trauma, maybe PTSD from this trauma or some other types of diagnosis. So parents and children with disabilities, there's varied diagnostics and dual diagnosis. How many of your parents have a dual diagnosis, which means that maybe they have major depression, but they also have alcohol use or some kind of addiction? Most people, right? Raise your hand. So it's very common because the truth is that most people are self-medicating, right? So maybe they're non-compliant with their psychiatric medications and they use drugs or alcohol to be able to manage some of those symptoms. But for us in this mental health field, we know that if you're drinking, that's actually a depressant. So you are going to get more depressed. And in some cases, it can get so severe that you can't get out of bed, you have suicidal thoughts, or you're engaging in some self-destructive behaviors. And that can also lead to neglect, right, with children. The other one is disabilities from point of birth. So again, some of these individuals were born with this disability. And some have temporary disabilities, which means that maybe there was a real stressful event that happened in their life that brought out the full diagnosis. So some people, when they're under severe stress, they're already predispositioned to have these different types of chemical imbalances. And when they can't manage their stress, it becomes maybe like a bipolar disorder, right? When people are not taking good self-care of themselves or not sleeping properly, maybe not eating properly, and again, maybe self-medicating, which can enhance some of these psychotic episodes that they have. And so believe it or not, some parents actually, they are not aware and they don't have the insight to know that what's happening to their children, like being sexually abused by maybe their partners or their boyfriends, or maybe the children being left home alone and being neglected, they don't actually have the insight to make that connection because some are just not educated while others are busy doing drugs and don't even pay attention to those kind of critical needs. And then obviously the other one that we won't really talk too much about is the physical versus the mental disabilities, but it sounds like you guys focus more on the mental. So for attorneys of parents with children in foster care, what are, from your experiences, some of the legal aspects? What are some of the legal aspects that you struggle with when working with this population? Specifically the parents.
I think their own judgment and taking advice and understanding when they fail to take advice, you know, what's going on with them, presenting information in a way they can understand it, and then separating out sometimes reality from what they want to believe.
And believe it or not, just like with some of us more high functioning people, we sometimes only hear what we want to hear, right? And maybe they're just not listening to what you're telling them, and so they block that part out. And so it's really important to keep reminding them and keep reinforcing what happened. This is the consequence if you don't follow through with this recommendation. Anybody else? Yes.
Well, I was going to suggest prejudice, social prejudices, and you have all the challenges like Diane mentioned, but you also have to, part of your role as an attorney for anyone is a counseling role. Not counseling in the clinical sense as you use it, but counseling them as to what they're dealing with, the system, the legal system they're dealing with. And at least in my experience, you have to tell them about prejudices that exist towards people with mental disabilities.
And what would some of those prejudices be from your experience?
That they're violent, they have a disposition to be more violent, that the simple fact of a diagnosis creates an environment injurious to their children. That's primarily what we deal with.
So, yes.
I was just going to say, in most of my cases, by the time I get the case, the children are already in foster care. So my goal or objective is to try to make sure my client, if they actually have a mental illness, is that I can show they're rehabilitated or can guide them along that process, because the goal is to be able to return the children home. Even though I represent the parents, obviously I don't want the children to be in danger either. So my client needs to be rehabilitated, or I have to show they already are rehabilitated and that their diagnosis does not define them as a parent.
Mm-hmm. And so from your experiences, then what do you do in that case? For example, with drug and alcohol abuse, do you tell them that they have to go to drug and alcohol treatment and complete a 28-day program? Or what do you tell them that they need to do?
Well, I mean, the agency, in this case DCFS, and the courts guide in terms of, it's not really a request, it's more like a directive, an order, than to do certain things. From my perspective, I usually ask them to go get an assessment at a drug treatment facility to find out what they need, because I'm not gonna tell them to go to 28 days if maybe that's not what they need. Maybe outpatient treatment would work for them. I send them for an assessment in that.
Great. And that's actually, that's the first step. So you're doing the right thing. And some places that you can send these individuals for a free psychological assessment is hospitals such as Chicago Lakeshore Hospital, Chicago Behavior Hospital, where these are free of charge so that they don't have to worry about paying for, these some high fees, correct? And that way those trained clinicians, such as myself, will be able to determine, does this individual meet criteria for inpatient services? Do they need an outpatient, more intensive IOP program? Or do they need to go directly to a substance abuse detox or a recovery program that can be 28 days or maybe even a longer 90 days so that they can maintain that sobriety and work on getting their children back? And then the other thing that I was just going to say with your comment was, we also always have to protect ourselves and know that these people, they're still good people, right? Sometimes they just make poor decisions, but they are irrational and unpredictable. And so you too need to know how to be able to protect yourself so that you don't get in a situation where they lash out on you. So safety is always important. Some trauma-based therapy methods and approaches. So we have the multi-model and the comprehensive approach, which really focuses on putting together a little bit of all the different types of theories so that they can fit this specific individual. As clinicians, I don't show up to a session saying, well, I'm only going to do CBT, which is cognitive behavior therapy, because I know that that works the best. When you're dealing with children in foster care, you want to know what kind of therapy approaches are there so that the clinician can recommend specific types of approaches that match this individual's needs. So we have individual therapy, we have empowerment therapy, we have group therapy as an individual, also depending on, are you sending the child or the parents for these sessions, and family therapy. Oftentimes that may be a little bit difficult, especially when those kids are just taken away in the beginning, because I don't think legally they're allowed to have any contact in the beginning. No, they can. Oh, they can still have some visitations. So, and then you have the trauma-focused CBT, which specifically works with children of trauma, and multicultural therapy, depending on what kind of cultural background these individuals have. So one of the most successful ones has been the trauma-focused cognitive therapy behavior. So you as lawyers, when you're talking to the judge and you're trying to come up with some type of a referral, you want to ask specifically for this trauma-focused cognitive behavior therapy, depending on what age group it is, or maybe trauma-focused play therapy when those children are under the age of 10, right? Yes.
Our clients are mostly adults, but the same theories apply.
Yes.
Many of our clients have been foster children themselves, have suffered sexual abuse, domestic violence, other types of trauma that they themselves are dealing with.
Yeah.
Would we still send them for this trauma?
Same kind.
Behavioral therapy?
And it doesn't matter if they're children, adolescents, or adults. They still suffered from this kind of trauma. It doesn't matter when it happened. You want to refer for specifics. Because if you just say, oh, I just want you to attend 40 hours of counseling once a week. Well, what kind of counseling is it? And if the clinicians are not asking the right questions, they're not getting the right type of care. And so we'll talk a little bit more about that as well. So then dealing with the criminal justice system. Obviously for the people that are adults that you're working with, victims can sometimes feel that they're losing control when they are not directly involved in this type of sentencing. Do any of your clients feel like this? Right? They all do, probably. And then if victims are kept well informed, they may feel as if they have some kind of process which then leads to empowerment. So when you have them more involved, you may see higher success. How trauma has impacted them. So examples of sexual abuse and past traumas. You want to know the signs and symptoms of this disability, and more specifically with adults. So maybe you also need to ask the right questions to figure out, to get to know them a little bit better so that you can understand them and you can be able to provide the proper referrals, and always consulting with whatever mental health agencies that you're referring to. Also, was this more of a direct trauma or was it vicarious? Sometimes, even for myself as a crisis counselor, I'm vicariously living through other people's trauma, and that can affect me in my work. The same with you as lawyers. Sometimes that can also affect you because you're vicariously living through them. So you yourself can also be traumatized just from the work that you do with these people, listening to their stories in and out, and some are very, very graphic and very disturbing. And then how severe was that impact? Remember that each individual is going to handle the trauma a little bit differently, right? When I was working on, as a crisis worker, I witnessed somebody get gunned down in front of me on 63rd Street. And I literally saw the guy pull out a gun and shoot another guy. And so it affected me for a little bit, but then it didn't bother me so much. Maybe for some of these adults or children, maybe that can be like a long-lasting kind of a traumatic experience that they just can't get over, right? Especially maybe if they know this individual or if there's a personal connection. So being aware of the just how severe was it? What really happened? So when you're looking for recommendations for your parents, for the guardians, you want to know what kind of qualifications do the counselors need, do the clinicians need. So you always want to look at somebody who has a L.P.C, which is the first basic one year level, right? So you can start getting your licensed professional counselor after you complete 2 years as a master's level clinician. The problem is that most of these agencies, they have a lot of interns, and so interns aren't even licensed because they're supervised. So they may not have as much experience as somebody like me that's been working in the field for over 7 years. So my background is the L.C.P.C. Another one that you can work with and refer to is the licensed clinical social workers. And then, of course, when you're recommending for a psychological evaluation, these are called psychologists. Psychologists have they have PhDs, and their focus is more on the psychological testing, the psychological evaluations. And then finally, for medication management, you want to refer out to a psychiatrist. But before you refer out to a psychiatrist, you probably just want to refer out for a psychological evaluation to see, does this individual even really need medications? Most of the kids that I work with in DCFS, they're taking 10 to 12 different pills a day, every day, and they're under the age of 10. So some are walking around as zombies, and some are non-compliant with their medications because of the severe side effects. Is it better to sit there and to kind of pass out and, you know, have a drool coming out of your mouth? Or is it better to be aggressive and to cause explosive episodes, right? Not just with children, but also with adults. So what are some goals that we should expect? So improvements by way of mental and physical, empowerment at the individual and familial level, knowledge of the disability, and then awareness of coping skills. How are your individuals coping with some of this information that you're providing with? I know that when I was responding to crisis emergencies in the schools, I had to call DCFS to make reports, and I had to inform the patients, or I'm sorry, the parents or the guardians that I'm gonna have to make a call to DCFS. And so right away, if you say DCFS, they're not gonna like you, and they may become violent and aggressive, and sometimes I had to call the police because they were threatening to hurt me, right? Because I'm the person that's gotta make the call. Any question, or I'm sorry, so how can we measure the treatment outcomes? And I know I spoke to Susan a little bit about that and how difficult it is. you want to know and look for SMART goals. So whoever it is that you're working with, that clinician should be able to provide you with specific, measurable, achievable results focused in a specific time-bound manner. So continued evaluation of the outcomes, and then if there is no progress, refer to other clinicians. Here's the thing I always joke about. Shopping for a therapist is like shopping for shoes. You can always be a size 7, but it doesn't mean that every shoe is going to fit you that's a size 7. Well, the same thing with therapists. Sometimes they may just not connect with that individual. And so then it becomes kind of a waste of therapy, right? And so the right thing that we do is if I don't see any progress, I may refer out to another clinician because maybe I'm not qualified to help this individual. Maybe this individual is still just in denial. And sometimes they just don't have the insight to see the difference. And in my experiences, you know, there's been situations where I literally evaluated the same person every single month at the psychiatric hospital for like 6 years back to back. Every single month for 6 years, they were hospitalized for 1 week at the hospital. And so then you ask yourself, how is that possible? Why aren't they getting any better? Well, as you all know, there's a big failed system within the mental health system in terms of the waiting period. There's a lot of community mental health agencies that are now closed, so there's not enough resources. And then the resources that are available, there's a conflict of the insurance, right? The better the insurance, the more quicker they can get in to get professional help and see their psychiatrist. The other thing is that some of these people, they just wait till the last minute. So let's say that they have a prescription for a psychotropic medication, and they literally wait till the last day when they're running out of their prescription to go and refill it. And how are you going to refill that medicine if you don't have an appointment with your psychiatrist? They usually don't just refill it for you. They need to see you. And so that's where the disconnect is, and that's where there's a poor follow-up. And so it becomes a real problem because then these individuals are in a crisis and they keep getting re-hospitalized so that they can be stabilized on these medications. So any questions from this part so far? Yes.
Yeah, about regarding the type of therapist, sometimes I run into situations where there's a certain, like domestic the counseling that needs to be recommended in a certain area, such as domestic violence.
Mm-hmm.
I know that the DCFS has said, well, we need to have, make sure that there's a counselor trained in that area, and there's a component of domestic violence treatment included in the therapy.
So again, there's a website and it's called psychologytoday.com. And if you put in the specialty of the kind of clinician that you're looking for, they will narrow it down by zip code to see who is an expert in domestic violence, who is an expert in addictionology, who is an expert with bipolar disorder or schizophrenia.
So what was the name of the second facility where you said that they could provide a free evaluation?
So actually, the ones that I've worked with are Chicago Lakeshore Hospital, which is at 4840 North Marine Drive. The other one is Chicago Behavior Hospital, which is in Des Plaines. Some other agencies, and I'm not sure what, where you guys work, if it's just here in the city, but there's Skokie and Turning Point. Yes.
Just a couple of questions. First, I represent some parents. A lot of times the kids have been diagnosed with some severe mental health problems.
Uh-huh.
And I almost universally they're medicated.
Yes.
So as a parent attorney, is there a resource that you can direct me to educate me and my clients on what is proper medication protocol for children? That's my first question. My second question is, when our clients are being evaluated, the parents are being evaluated, can you weigh in on, particularly on the IQ component of a psychological evaluation, the value of adaptive functioning, testing? Maybe I'll leave it at that. That's probably.
Okay, so the first one is, there are a lot of, repeat the question. So the first question was, how can you get more educated on the medication management for children and the guardians so that you can get a better understanding of the medications? And that answer is, you have to find somebody who is a psychiatrist. That is a doctor, a medical doctor, who is also trained in psychiatry. And with children, you want to look for a child psychologist. One of my favorite psychiatrists that I work with that specializes is Dr. Scott Feldman, and he works with Chicago Behavior Hospital, Chicago Lakeshore Hospital. And so he is a very well-known child psychiatrist. So I would recommend, and I can always help you with that, is to bring him in on some future presentations, because he would be the one to answer some of those questions, and I can definitely connect you. There's another doctor that I work with at another hospital, and she's really good with children and adolescents as well. And so the medical medication questions kind of go to those answers, because I'm not qualified to answer that. And then there are now a lot of psychiatric nurses. They're called nurse practitioners. And I also have a friend that I used to work with. Her name is Lori, and she helps with medication management education because she's qualified to be able to answer some of those questions. The second question was
adaptive functioning.
Adaptive functioning.
For the low IQ.
Oh, for the low IQ. So again, for those individuals, it started off back in our DSM. Our DSM is kind of like our Bible for clinicians and psychiatrists. And it used to be called, there were different levels, and it was called like mild retardation, and then there were different, like how severe is it, different levels of functioning. But in the new DSM, they pulled that word out because a lot of people found that it was very kind of degrading, and so they changed that diagnosis to developmental, and so those individuals now have these developmental issues. Diagnoses, and those individuals that would test for that are the psychologists. So that's why when you send these people to get a psychiatric evaluation, they will also get a counselor, they'll get a social worker, they'll get a psychologist and a psychiatrist to be able to give you a full evaluation. Yes.
I'm not sure what Louis was talking, if this is exactly the same, but what we see a lot of times is that the person may have a mental health diagnosis like depression or something, and then they may also have what is a fairly low IQ, say 68, 69.
So they can be dual diagnosed.
But then the question becomes, what type of testing should be done to test what that person's real level of functioning? I know back in the day, there was the Vineland, there's different, what is the right, I know the basis for IQ, but what, is there a specific test we should be asking for to actually gauge their level of functioning? Because their IQ score may not necessarily tell that whole story, right?
Yeah, it may not. And again, I don't rely on just one kind of a test. I think that there needs to be multiple tests. I know with children, they sometimes do this IEP testing in the school systems. For adults, once again, it would probably be more effective for you to speak to a trained psychologist because they have that testing experience. I only have a little background on it, and I don't want to tell you a specific test that I don't think that just one tool will be able to measure all of that. Yes?
I have another question. Well, it seems that some of my clients get a case manager.
Yes.
And other people don't. And the ones that have a case manager assigned to them through the community mental health center or whatever outpatient setting that they're in seem to do way better because there's somebody, a support person there to make sure they get to their appointments, that they're really getting their medication refill, that they're not waiting till that last day. Can you tell us any way to help how we
or is there any way to help guide our clients to somebody a facility that is going to be assigning a case manager? Or do you find that experience true as well, that there's better compliance and better results with the case manager?
So case managers, most of the ones that I've worked with, they're only bachelor level clinicians. And so case managers do work in this agency that I've been working with Ada S. McKinley. But again, I just noticed that there's a really big waiting period to get to see these case managers. The other big popular one that's happening right now is called a community support specialist. And I did that for 1 year with Illinois Masonic. There's a program called the Mixed Team. And with the Mixed Team, we're working with individuals who not only have a legal problem, they also have financial problems. Most of them are homeless, and they have medical problems, and they also have a lack of support, right? Their family doesn't really support them, or maybe they don't have any family. So they have a combination of these 5 stressors. So places like Thresholds or the Mixed Team are really good resources, because what I did for 1 year when I worked full-time with them is I actually followed this person around. And so I met them out in the community. I would take them on the Red Line to the library and teach them how to use a basic computer. I would educate them on their current legal situation. How do we help you? How do we support you? And go to you, right? A lot of those people, they don't have any money for transportation. So we were able to have this budget to be able to, take them on public transportation to go to their court appointments, to go to get their medications. So this community support teams are becoming very, very popular now. So I would refer to that, yes.
Somebody online wants to know where Lori, the nurse practitioner, works.
Lori works currently, she has her own, let me just look that up real quick. She works independently, but she also works more in the North Shore. Let me just pull that up right now. Lori Moreno, and she is psychiatric nurse practitioner, used to work at Highland Park Hospital, and now I can't think of, she didn't put it on here, but I can follow up with that. I can't remember, it's in Northbrook, I think, or Highland Park. She recently switched, but I'm sure she'll be happy to have me give her phone number and her email. And then again, you guys can also email me. My email address is counselingspeaks@gmail.com, so that we can be able to give you more resources in case that comes up. So the next 15 minutes, I wanted to briefly go over another presentation that I think may be important as well for you. 1 second here, let me just pull that up. And then I'm not going to go through the entire presentation, but just some key parts. Chicago Bar Association, okay. Okay. So this PowerPoint talks a little bit about strategies for non-helping professionals working with individuals afflicted with mental health disorders. And I think that this is really good information for you too, because you are non-helping professionals. In a sense, you're not clinicians or social workers. So here we're going to just talk a little bit about understanding mental illness so that you can get a better idea of what it is, and just get a little bit information on knowing that these people, they do not choose to be mentally ill, right? There's a combination of environmental, biological, social, personal, psychology that is taken into consideration. You know, when I worked with heroin addiction, I often told myself, you know, it's so easy to blame people and judge them, right? But to be honest, do you know anybody that woke up one day and said, oh, I'm going to be a heroin addict and I'm going to inject myself with heroin? I don't think that people have that goal, right, when they wake up. So it's some things that sometimes they can't control with their addictions and so forth. And then just a difference about what is mental health and what is a mental disorder. Mental health is just a state of complete physical, mental, social well-being, and it's really access of disease. So mental health is like all of us, right? It's kind of like a lifestyle. How do we take care of our mental health? Do we exercise? Do we eat properly? Most of these people that we're working with, if you're familiar with Maslow's hierarchy of needs, they're down here at the bottom. They're just trying to survive to pay their basic bills. They're trying to be able to feed their kids. They're no way near where some of us are maybe at, right? So pay attention to when you're working with individuals in your situations, where are they on Maslow's hierarchy of needs? Because those basic survival skills are the ones that maybe they're focusing on just to survive. And then mental disorders. So it becomes a disorder when it becomes a disruption. So again, it goes back to individuals that cannot keep a job. They're constantly getting fired because they're skipping work, or they're very impulsive and maybe they're verbally aggressive with their colleagues. So maybe some of these parents are the ones that you're working with. Impact on the individual, couple, family, and society. And again, you can apply some of this information into the population that you're working with. They become angry, chaotic, maybe they're going also through divorce, maybe they're not even married, there's some kind of drug and alcohol use, they feel a lot of hatred, some may be suicidal or homicidal, some of them may be stuck, hopeless, helpless, sometimes they're engaging in a lot of self-harm, which could be, cutting episodes, or maybe, I worked with a young woman who used to swallow sharp objects. That was her addiction. And of course, some may have a lot of sorrow and sadness, lots of relationship difficulties. So when you are more mindful of all these things that affect them, maybe you can get a better understanding of when they start attacking you or when they yell at you and make you feel uncomfortable in some cases. Discussion of some common misconceptions. Obviously, mental illness is a choice. No, it is not. Those with mental illness enjoy being that way. No, they do not. They do it for attention. Some truth. I can see, 16-year-old girl telling me, oh, I just wanted to kill myself because my dad wasn't around in my life, right? So they're able to sometimes verbalize that if you ask the right questions. They can just snap out of it. No, actually, most of them cannot snap out of it. Mental illness isn't real. It's actually very real. And seeing a mental health professional is a waste of time and energy. Again, it's what you put into it. Yes, it can be a waste of time and energy if you're not being true to yourself and to the clinicians. I always tell the people I work with, I'm not a fortune teller. I can't read your mind. So tell me what's really going on, right? Just some basic common disorders. You have general anxiety, you have some OCD behaviors, panic disorders, persistent depressive disorders, PTSD, maybe social anxiety, and then again, there's some more intense diagnoses like schizoaffective disorder, schizophrenia, bipolar disorder, which is under mood disorders. What kind of disorders do you usually work with your clients, your adult clients? Personality disorders. So those are really hard to treat, right?
Substance abuse is probably the number one.
Yeah, and a lot of people get really frustrated and they kind of get burnt out with working with individual with drug and alcohol problems. And so the best referral for those people is somebody with a CADC qualification, which is a certified drug and alcohol counselor, because they're trained, yes.
I've always tried to keep in mind with the substance abusing client that, well, at least my pet theory has always been that nobody starts out just as a substance abuser. There's usually some sort of underlying pain or trauma that leads them to go down that path.
Absolutely.
So that's my mental trick to try to remain patient. Very frustrating client.
That's great. And so when I'm working in different settings, my work is to evaluate when they're coming into the psychiatric hospital. My job is to assess and find out, is this individual drinking alcohol because they are depressed, or are they depressed because everybody knows that alcohol is a depressant? So it temporarily makes us feel good or mellow or whatever. Some of us get angry or happy, but then what happens 2-3 days after you go on this binge drink, right? So it's really, again, for clinicians to be able to assess that. What is the primary diagnosis?
Question or a comment about alcoholism. Isn't that considered a disease that affects some people and doesn't affect others?
Oh, absolutely. And actually, in my personal life, I grew up with a grandfather who's an alcoholic, and I have a couple uncles who are alcoholics as well. And so I was blessed with being skipped, right? So it skips generations sometimes, but I'm always worried that one day if I have kids, they may be alcoholics because it runs in our genes and in our culture, because we're Polish, you know? So you're expected to drink vodka, right, socially. So yes, it's definitely something to take into consideration, is that if you have a history of it, you should be more aware of what your choices are. So just a little bit about the relevance of mental illness, and of course I got this information from NAMI. I'm super passionate about referring individuals to NAMI, which is the National Alliance of Mental Illness, and this is an organization that I helped volunteer and serve on the board with Susan. And so approximately 1 in 5 adults in the US, which means 43.8 million, experiences mental illness in a given year. That's really high. Approximately 1 in 25 adults in the US, or 10 million, experience some kind of a serious mental illness in a given year, with or limits one or more major life activities. And then we have youth age 13 to 18. They also experience a severe mental disorder at some point during their life. 1.1% of adults in the US live with schizophrenia. Now the most popular one diagnosis that I work with a lot with outpatient studies is schizoaffective disorder. And 2.6 of adults in the US live with bipolar disorder. So again, they're unregulated, right? They go from up and down sometimes, very, very depressed where they can't get out of bed, or they're extremely manic and they have no idea what they're doing. There was a woman that used to come to one of our psychiatric hospitals who was hospitalized literally every month. She was picked up by the police because she used to rollerblade half naked on the streets of the city. So they would always bring her in, and that's when we knew that she was off her medications, because normally people wouldn't be doing that, you know. 6.9 of the adults in the US, which is about 60 million, had at least one major depressive episode in the past year. And so that criteria for that episode is being persistently depressed for at least 2 weeks every single day. So for those 2 weeks, they felt hopeless, helpless, worthless, didn't want to get out of bed, just decrease in appetite, maybe a disrupted sleeping patterns, maybe they're sleeping too much. I recently evaluated a woman who told me part of the assessment, the question was, how many hours do you sleep a day? And she told me 15 hours a day. And I said, well, if you're sleeping 15 hours a day and you have a 3-year-old and your husband is working, I said, who is watching your child? Right? And then she felt kind of, oh, now I'm an unfit parent. I feel bad. What am I going to do about that? And I was trying to educate her that it's not about being an unfit parent. It's more about responsibility. If you're depressed, who can you find to watch your child when you can't get out of bed, right? So 18.1 of adults in the US experience something such as anxiety and PTSD, OCD, or specific kind of phobias. Believe it or not, a lot of people have anxiety problems. and they can be really high functioning people that have anxiety problems. What do we know about, America is that it's socially accepted to go out after work and have a few drinks, right? Because there's something wrong with you if you don't have a drink in your hand and you're going to a happy hour or whatever after work. So sometimes I trick people and I just drink water and, they tease me about it and they're like, what are you, an AA? And I was like, yeah, sure. Among the 20.2 million adults in U.S. who experience a substance abuse disorder, 50% or 10.2 million have that co-occurring mental diagnosis, right? So they have a dual diagnosis, mental illness. And then what happens with these addictions is that sometimes the individual will have a cross addiction. So maybe they're going to go from drinking alcohol and then they're going to sober up and stay clean, but they may start gambling, right, excessively. Or maybe they have a sex addiction. I'm interviewing so many men and women now that are meeting people on Craigslist, right, just to hook up and so forth. So cross addiction, right, knowing how are you actually really treating this addiction? Or do they go and they start shopping excessively? Some other statistics that we won't go into detail because you'll have access to the slides later is 70% of youth in the Juvenile system have at least one mental health condition, and at least 20% of them live with a serious mental illness, so you already probably know this. Just a year, over half of children age 8 to 15 received mental health services in a previous year. African American and Hispanic Americans use mental health services at about half the rate of Caucasian Americans in the past year, and Asian Americans about 1/3 of the rate. And only 41% of adults in the U.S. with a mental health condition received mental health services in the past year. So again, just some statistics for you. What are the consequences of lack of treatment? So when these people are not following up with what the recommendations are or what the court orders, what happens? Mood disorders, major depression, and some of these other disorders, they are the third most common cause of hospitalizations in the U.S. for both young and adolescents and adults ages 18 through 44. Individuals living with a lot of these serious illnesses also have a higher risk of having a chronic medical problem. So those are some of those people that I told you about that I was working with. They had a list of stressors, right? Medical, financial, mental, legal, and relationship. Suicide is the 10th leading cause of death in the U.S. So again, how many of your individuals are suicidal? Some anxiety disorders, information that you probably don't need to know too much about, OCD disorders, some simple phobias, some just clinical kind of information on major depression if you want to read it later. How do you identify potential mental illnesses? Monitoring their behavior and the way that they respond to you. So just being mindful of the way that they present themselves when you're meeting with them. Most of the times, maybe they have poor hygiene and they're being unkept. Other times, you can notice that they're really agitated or irritable or anxious, very defensive sometimes, and they can yell at you directly. So things that they can say is, oh, you're out to get me, I can't do this, the world is against me, the government is spying on me, if they're paranoid, I'm sad all the time, nobody can help me, I hate everything. So those are just some things that they may say. Things clients might feel uncomfortable discussing, obviously, is legal situations for you, right? They sometimes don't want to discuss that and they're in denial. And then ways to address your clients. So you always want to be respectful, right? We never know what people are really going through. Even though you may get a lot of history on them, you don't know all the details and you also don't know how true is it. Asking questions as necessary, being very directive, being very professional, keeping calm and collected. I know that when I sometimes have like a freak out moment where people are yelling at me, I have the principal, the parents, DCFS, the police, and the kids, everybody's screaming. I sometimes wiggle my toes and I ground myself and I remind myself this is not my fault. I'm just here to be that helper. So maybe something like that is something that you can even use, or maybe grabbing like a necklace and just kind of grounding yourself and feeling that to take away from all that chaos. Stepping back from the frustration, politely excusing yourself so that you're not responding. If you notice that people are yelling, the best thing to do is to whisper. I always imagine myself being in a library, so then I speak a little bit softer and quieter, and then I notice that they also stop yelling, and they're like, oh, why are you talking so quietly? And so then it kind of brings them down. Being mindful, again, of your client's needs, some ethical kind of questions, setting really good boundaries for yourself, too. Do not do any kind of favors. Don't ever make promises. And do provide a lot of mental health resources, right? And then finally, always be mindful that safety is always first if you are alone with these individuals. And finally, noticing some of these high-risk kind of situations, if they become hostile or threatening, how to be able to safely remove yourself. And then keeping them safe. Being able to call 911 if your situations ever become really dangerous. I'm not sure, are you guys alone with these people or more controlled settings? So just always being aware of the situation, keeping yourself safe, and then providing them with available resources. The one place that you can always refer to, no matter where you are immediately, is going to the nearest emergency room. And so every emergency room has a crisis worker, and they'll be able to handle it from there. And then finally, we already talked about the different types of mental health professionals. Working with those case managers, DCFS, SAS, different support groups is also just another resource slide for you. Some of these are old. Community crisis providers. I used to work with Community Mental Health Council many years ago. They're closed. C4 is also, they were in kind of a crisis. I'm sure you heard on the news that they were kind of closing. Some of the other facilities are still open. And then just being really direct, genuine, polite, help when necessary, continue on with being able to manage your expectations and your boundaries. Working with them with the network, if they have family members, trying to just have everybody kind of be involved, and then understanding some of their pitfalls. Recognizing burnout for yourself. I know that I've been burned out many times when I'm working with 10 different chronic mental health situation cases on a day-to-day basis. Sometimes, one of my favorite things to do is to practice yoga or horseback riding so that I can keep myself kind of clear-minded and quiet, right? And then specifically self-care for lawyers again. So just go to a concert, have some fun, call your friends, family members, cuddle with a pet. Everybody knows pet therapy is really good. Eating your favorite foods, going on dates, listening to music, meditation, reading a book, praying if you pray, just kind of taking some time for you, because I know maybe some of you are so passionate about your career that you often forget about yourself. And if you're not healthy and if you're not taking care of yourself, how could you be strong to help the people that you work with? All right, lots of information. Any final questions? We still have 7 minutes. Maybe I didn't answer something for you. Yes?
Could you just distinguish again between the licensed clinical professional counselor, which is you, right? Mm-hmm. And the licensed clinical social worker?
Mm-hmm. So social workers focus more on the social problems. Every hospital and nursing home, those types of facilities, some social workers are in private practice as well, but they're very resourceful in terms of the community kind of resources, whereas counselors, we focus more on the individual. So actually, when you're referring to counseling, my recommendation would for you to refer to counselors, because we're more trained on individual and like family therapy. Although the two are still kind of, used for different different reasons in different areas. I just prefer counseling because I'm a trained counselor, so that's just the one that I would probably refer to.
So, if there's like, they are also allowed to do
Yeah, they are. There are some LCSWs that do provide counseling, but again, they were trained more to address social issues, not so much individual counseling, therapy, and diagnosis. Yes.
At what level do people diagnose mental health?
So I actually do preliminary diagnosis. Depends how often you see the individual, but after master's level and your license, you can diagnose because we're mandated to do that for insurance purposes, right, and billing. We have to give a diagnosis. Yes.
I just want to, I have the MSW, I just want to clarify, depends on the program where social worker is coming from. For example, my MSW, which is from Loyola, is an extremely clinical program, and we're taught only to be basically individual therapists. So I wouldn't not recommend the social workers here in LCSW, they have been able to.
Okay. So my background again is specifically counseling. So I'm not familiar with what kind of training social workers get besides what I've been exposed to with my colleagues. Yes.
When you're treating a particular individual in the techniques that you described earlier, particularly the cognitive behavioral and the trauma-informed cognitive behavioral, how, if at all, do you have to modify those techniques when the person you are providing the therapy to has an intellectual disability or has been diagnosed with borderline intellectual function?
So I don't have too much background with those individuals again, but I would really recommend finding somebody that specializes with that. And again, Psychology Today is a really good resource because when you type in developmental disabilities or specific kinds of disorders that you want to refer to, intellectual disorders, those would be the kinds of clinicians that you'd want to refer to. Yes.
I'm thinking back to your lady that you encountered recently that said she was sleeping 15 hours. And then she has a child. And so in somebody like that, would you have, in order for her to keep her child, would you have recommended like helping, like send her to somebody or you yourself work with her to develop like a care plan, daycare, try to develop her social network, a support system?
Yeah.
Do those kind of things help her keep her child? Or be an effective parent?
So in this case specifically, the reason why I evaluated her is because her husband brought her into the psychiatric hospital for evaluation because she was just sleeping way too much and the depression was getting so much worse. She was also engaging in a lot of self-harm, so she was cutting on her thighs and her arms, and he was really concerned about leaving the child alone with her, so he kind of stepped in to prevent further decompensation. So she was hospitalized. I recommended for inpatient hospitalizations so she gets stabilized, and once she gets stabilized, then the social worker from our hospital would be working on that kind of a treatment plan to make sure that do you have like a sibling or a parent that can be in the house when you start having these types of episodes.
Okay.
But I didn't do that. I only did the initial assessment.
Yeah, okay. So I wanted to thank Kasia for giving us a little bit of reality in terms of their therapeutic approaches to the problems that our clients presented. I think some of those statistics were pretty overwhelming in terms of the prevalence of these issues, not just in our practice, but generally. So we could hear, the broader perspective. So thank you very much.
You're welcome. Again.
going to have more discussion. Kent has done some additional questions, and we wanted to have more audience discussion. Kent, do you want to come up with any additional questions? Steve, Susan? I think that when Kasia at the end highlighted, some of the self-care issues, I think when we, talk about our practice, and it's not just mental health, but it's all the different social problems that come to bear in the juvenile court, it can be very overwhelming. And I think her about the need for self-care is really, really important for us as a parent attorney network to keep going and to keep pushing for justice. We have to be taking care of ourselves, and that's part of the reason we view this as a support network for all of us, to take a day off and get some training and think about things and then go home and relax for the weekend after we finish tonight.
I want to emphasize about something that Kasia brought out, statistics. It's a very important reminder, as far as mental health. But we're basic on money, so simple as that. It's like light, hit anybody. So, to satisfy our PMLC, credits, we really want to finish up a little bit more time on the panel, so bear with us. I have one final question, and I want the audience to definitely, throw back at us. Have any of you, we certainly here at the panel have some, ever used an expert to help you understand how to work with the client, or used an expert to, probably more likely, used an expert to challenge the prevailing diagnosis that is being used against the client? You had any experience of utilizing an expert? Got a knuckle out there. Anything that really stood out about using your expert? Mental health. Mental health. Yeah, I think most all of us have used an ortho somewhere along the way, but mental health maybe not so much.
On mental health, I've actually got a case right now where a guy, for no apparent reason, broke out of the Department of Corrections when he had less than 3 months to go on his sentence, and just kind of went for a walk. And turned, and the next day he walked up to a cop and said, "Here I am." And
I think that warrants an evaluation.
That was my position. And the first psychiatrist talked to him, or psychologist talked to him, and said, "There's nothing wrong with this guy." So I'm having actually that's who I was stepping out to speak to, another psychiatrist actually come and talk to him more in depth now that I have more of his mental health records.
This is a criminal matter?
Right.
Okay. So remember, the audience has a client who I guess you requested evaluation, right?
Correct.
In a criminal matter, and the first evaluation came back, this guy's fine. Despite, from what I heard, I don't see how he is.
And how does that make sense?
Yeah.
When everybody that knows him, even the people that did the internal investigation on how he managed to basically just walk out of a Department of Corrections facility.
So in your case, you had a guy who you asked for an evaluation, you got the evaluation back, and quite frankly, doesn't sound right.
That was exactly my impression, because I had talked to this guy, and he is childlike, would be the phrase I would use. And when the later on, I was asking for another psychiatrist to be appointed, and the judge, fortunately, took some time to talk to my guy, and he's like, "I don't think this guy's fit." And he appointed another psychiatrist to talk to him.
There you go. And that's, sometimes you got to try again.
Exactly.
Ms. O'Neill?
I was just saying, I haven't had very good luck lately, so you know that about getting experts. But anyway, back in 2001, I had a client I was representing in juvenile court who had murdered his child's mother, the child's mother. And he had a long history of mental illness, and I couldn't get a psychologist to go to the jail, but I got the judge to approve a psychologist reading all of his records, and which I obtained. He had records like this, psych records, and answering specific questions because the state filed expedited termination alleging depravity. And at the time in Illinois, there had never been a case, even though the case law had defined depravity as being unwilling or unable to conform to the mores of society. No one had ever terminated somebody's rights on depravity for a mental illness before. They had gone to paragraph P. So I was trying to get out of the psychologist about his decision-making capacity and what he would view as right and wrong. Ultimately, the judge said, well, she didn't care what the psychologist said, that he was unable, perhaps, to conform, but that was still depravity. And I did lose that at the appellate court level, even though that it never happened before in Illinois. They said, well, unable is unable. Well, I had to try something. In that case, actually, it was about the grandmother. The grandmother, if the rights were terminated, the grandmother, who had done nothing wrong, that his whole side of the family was no more. And that was very heartbreaking because she was a very nice woman, and it was very sad.
So our office had a case a while ago involving a mother with bipolar disorder who had a bipolar, a manic episode. Initially, she had a safety plan, and then, at the end of the period of the safety plan, they wanted to go on vacation, and the department decided that they couldn't just continue this case with informal arrangements. They needed to go get a court order to require ongoing treatment. So DCFS goes and petitions the case, and the state approves the petition seeking an order of protection. The public guardian, however, when the case came before the juvenile court, decided that they wanted to seek custody, and the court granted temporary custody, even though neither DCFS nor the state's attorney had asked for custody. It took 2 years effectively to return the child, and I think that the entire case rested on stigma and fear of bipolar disorder, which the judge, would talk about risk, but there really was no evidence of risk. And it took a lot.
Took the diagnosis.
They took the diagnosis as risk, and it took a lot of psychiatric, testimony of her psychiatrist, testimony of, other socialists. We had a licensed clinical social worker who had worked with a lot of mothers with mental illness to convince the judge to even move towards, increase unsupervised visits and eventually return home. We ended up taking an appeal on the unsupervised visit issue, and I think the court kind of ducked the issue, as I recall. So I think that is an example of where psychiatrists really and psychologists really need to explain to the court that diagnosis of these disorders doesn't equal risk of harm.
And where did you go to get your experts?
Well, she had good treaters.
Her own treaters.
Her own treaters. When people have mental health, bipolar disorder, many of them have. They're seeing a psychiatrist. She may have been off medication while they're pregnant. I mean, we get cases where people are off medication while they're pregnant, and then incidents happen. And that was actually, I believe, the precipitating incident was she was shortly before going back on medication that there was an episode. So.
Stephen, you ever retained anybody? Retained an expert? Or just used your client's own already existing treaters?
No, we generally don't have a budget to retain experts at LAF, so I've never had to challenge a diagnosis. What I would say, and I guess since I've got the microphone, I'll make some unfair generalizations. I have confronted a psychiatrist with this, and at some point said, you know, you guys are the most conservative, aren't you? It goes, you guys, then psychologists, then social workers and professional counselors, right? And he grudgingly agreed with me. So I guess to the extent that I would have any advice, and I guess what is interesting to me, because this is reflective of my own prejudices, but you know, in many ways, a clinical professional counselor like the person who presented, or a clinical social worker who has worked with someone over a period of 2 years is really in the best position to offer opinions as to their mental state, their level of insight, and that type of thing. But it seems to me as a lawyer, when I'm trying to get a case together, if I have the funds to hire a prominent psychiatrist, I'm going to do that too. You know, my impression of juvenile court is that it's driven by prejudices, lowercase p, about mental illness and about who is best in a position to decide whether somebody with mental illness can function as a parent or not. So get a psychiatrist if you can.
I want to throw one more out there. As our last session, last time we all got together for these trainings, we talked a lot about the juvenile court clinic, which is here in Cook County. Different jurisdictions have different equivalents. Some have nothing, but you know, that's another tool too. I know there's a lot of criticism at times about the juvenile court clinic reports here in Cook County, but you know what? Sometimes they actually are a little skeptical of prior treaters' conclusions. I've seen those. I've seen them saying, okay, I understand that, you know, I may not like much else that's in the report, but somewhere along the way in the report it says, you know, this treater has this diagnosis, and considering all this other information, this may need to be reevaluated. They always say it in a very diplomatic way, but it's clear. So sometimes, you know, even that's a tool. You know, obviously you don't have the budget, you don't have the resources, or the client doesn't have the budget or resources to reach out and get your own expert. Sometimes a tool like that, which is part of the court system, but it may, if you get the right assessor, can actually be useful for you. With that, our part.
Yes, I wanted to ask Amanda Walsh if you wanted to give a few words about your project, because I think people here might be very interested if you wanted to come forward. Amanda is on an Equal Justice Works Fellowship to do a mental health legal partnership project with, it used to be called AIDS Legal Counsel, it's now called Legal Counsel. So Amanda, do you want to come up? I think people will be excited to know about this.
While Amanda's coming up here on a couple housekeeping things, do not, please everybody, those of you online, your course evaluation forms, please complete, scan them back to Brian. And those of you that are here, please give me your evaluations before you leave. Put them in the file. Certificates, because we sent the application in pretty close to today's date. Certificates or approval is pending. I do not expect any difficulty. I will mail certificates to the participants once we get the approval. Thank you. Thanks for your patience.
Hello. So like Diane said, my name is Amanda Walsh. I'm an Equal Justice Works Fellow at the Legal Counsel for Health Justice. A little bit of my background, I have both JD and MSW, and I'm actually also completing an LLM in health law. I'm presenting on my thesis tomorrow, which is about mental health parity laws. So my project is using what's called the medical legal partnership model. So this is a model that's been around for about 10 years that had partners lawyers with traditionally doctors or that treat traditionally physical conditions to train the doctors how to legal spot issues. So the issues that are what we call health harming legal issues. So for example, an example that's always been used is if a child keeps repeatedly being hospitalized for their asthma, training the doctor to be able to ask the parent, well, what's your housing condition? And then figuring out, oh, there's mold. Okay, so we can get a doctor involved and then we can help improve the health outcome of the child. So I'm expanding the model to behavioral health. I think the behavioral health field is particularly really well suited for this model because as a prior presenter mentioned, social workers in particular are very trained to recognize social impacts. And as we all know, being lawyers for individuals with mental health issues, there's a lot of external issues that are coming into play. For example, for children with mental health, it might be that they don't have the special education services they need. For the adults, it might be they don't have the benefits that they need. And by partnering a lawyer with the physicians or the behavioral health providers, like a psychologist or social worker, you can then start intervening sooner and try and help that family stabilize. So that's my part.
I wanted to mention how it's affecting like juvenile court or foster care.
Sure. Yeah, so the goal of my project is really stems, I'm a former law clerk from the Family Defense Center. My project is really stemmed into how do we prevent these families from entering into the foster care system, or if they are, how do we use everything that we learned today to help the families because of their mental health needs. I know a big passion of mine is how do we stop custody relinquishments from happening, of children being placed into care solely for mental health issues. So I'm still finding a partner right now, but I hope to help influence policies through the model.
Thank you. And with that, I wanted to invite, if you're interested in becoming part of the leadership of the Family Parent Attorney Network, please let me know. We try to have monthly meetings. We try to plan training programs that are going to meet the needs of attorneys who represent parents all over the state. So please let me know. And thank you.
You meet by teleconference.
Yes, we meet by teleconference.
Good to know.